So I want to make sure, my notes were not very clear here. It looks like, first of all, she was charged with 3 different counts. She had OWI occupant second, less than 16, which, as you know, is a 5-year fine. She also had 2 other counts, which were consisting of, let me just give me a second here. Which consisted of a charge of OWI second. That was set forth in count 2, which was also, it was actually a high BAC, OWI high BAC set forth in count 2. And then she also had a charge of operating while impaired second. As far as I can tell from my notes and everything here, she pled to OWI occupant less than 16, a 1 year. The felony count relating to the OWI occupant, as well as the super drunk. And Heather, I want to make sure that everything is reflected accurately. I did not make very good notes on the register.
Beth did come down this morning and speak with Lisa about it. So I believe everything should be correct in the system now.
Right. So I also had, but I want to be clear about this. So count 1, there was a plea to the lesser included of OWI occupant less than 16, a 1 year. Count 2 was super drunk second with the prior, which is also a felony, that they went ahead and dismissed. And then count 3 was operating while impaired second, which they also dismissed, but a count was added of child abuse in the 4th degree. So I'm going to sentence, which is also a 1 year. So I'm going to sentence on the OWI occupant less than 16 and child abuse 4. I'm going to put it on our sobriety court register. As to OWI occupant less than 16, the terms are going to end up running concurrent. As to
Vonenberger, right?
Yes, yes, sir.
Represented by Ms. Shy. We have Mr. View from the prosecutor's office. We're here today for a pretrial. It's my understanding Mr. Vonenberger is going to enter a plea of guilty to the strangulation and domestic violence. We're going to set it for sentencing, right?
Yes, Your Honor, that is correct.
All right, Mr. Vonenberger, how old are you?
43,
How far did you go in school?
9th grade.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
Yes.
What are you taking?
Lazapine.
Are you taking anything that would interfere with your ability to understand what we're doing here today?
No.
Are you a United States citizen?
Yes.
We've had some discussions about your case. If you enter a plea of guilty to these charges, I'm not going to sentence you today because I don't know enough about you and I don't know enough about this case yet. I'm going to do a pre-sentence investigation, also an evaluation to see if you are appropriate for a community-based corrections facility, which seems like the way we're headed. We're going to come back here in about 6 weeks for sentencing. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, Your Honor.
I have a document entitled Change of Plea and Entry. On the second page, there's a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Ms. Shy before you signed it?
Yes, I did.
Are you satisfied with the representation that you have received in the case?
Yes.
You're going to enter a plea of guilty to 1 count of strangulation, 4th-degree felony, punishable by up to 18 months in prison and a $5,000 fine. If I were to send you to prison on the case, the maximum penalty also includes an optional period of post-release control of up to 2 years, but there is no mandatory prison in the case. I can put you into my community control program. Also, we have a domestic violence, which is a 1st-degree misdemeanor punishable by up to 180 days in jail. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, You're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir, Your Honor.
Mr. View, was the state able to confer with the victim prior to today's hearing?
Yes, Your Honor. The input we have from the victims, they are in agreement with the resolution.
All right, what are the facts?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on October the 31st of 2025 at the defendant's residence in Deerfield Township, Warren County, state of Ohio, that the defendant caused a substantial risk of physical harm to Shannon Carey, a family or household member, by means of strangulation, and additionally caused or attempted to cause physical harm to Avaya Akers, also a family or household member.
Any on those facts, Ms. Shy?
No, thank you, Your Honor.
Mr. Funderburger, did you hear those facts?
Yes,
Do you admit they are true?
yes,
Do you understand the rights you're giving up by entering a plea?
yes,
Is this what you want to do?
yes.
What's your plea?
Plead guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think you've made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. Not going to go into the matter of the sentence today. We're going to do a level 2 pre-sentence investigation, CBCF evaluation, see everybody back here in about 6 weeks.
Thank you, Judge.
All right, that's all.
Your Honor. Okay. If you have any questions, give me a call. Okay?
As to that charge and the child abuse fourth, and then all other charges will be dismissed. That being said, have you had a chance to review the report? Do you agree with all of that?
That's correct, Your Honor. I just double checked. Yes.
Yeah, I mean, I just, they did this on a little bit different form because it was sobriety court. And that's it. That's all I'll say about it. I did, for the record, a victim's rights notice was sent to Mr. Hughes. I believe it's Mr. Hughes. Just give me a second. Yeah, Josiah Davis, care of Forrest Hughes. Is that individual here? That individual is not here. You can go ahead and proceed. Have you had a chance to review the report? And are there any material additions, corrections, or deletions?
We have reviewed the report. The stand has also reviewed the report. No objections or corrections.
All right. Anything you would like to say?
Very briefly, Your Honor, I sent, and I apologize, I just gave it to the court today, sort of a bullet point letter. And if the court doesn't have it, I have a copy I can give you right here.
I don't believe I've received that.
I will hand it to the court and I will summarize it very quickly.
Okay, you can hand it up. Thank you.
Because although the pre-sentence report's accurate, Your Honor, the question is, why does this keep happening to Ms. Dan? And I think that's what I kind of lay out very quickly in my letter. She was, I don't want to get into too many details of the report, but she was the victim of some abuse multiple times as a child. And her substance abuse stems not from her desire to party or have fun, but to deal with this trauma. Which will segue into, she's aware of that. She was taking some medication to curb her ability to drink. Then she got pregnant and had to go off it.
Vivitrol.
Correct, Your Honor. She has, since her arrest on this, been working on her addiction. But I think more importantly, the underlying issues, going to mental health counseling, going to meetings, going to family counseling, going to individual counseling. Talking to her today, she says, every day she has some sort of meeting, some sort of therapy to go to. Recovery for her has been a full-time employment, really. One thing she wanted to do today, but she said she just couldn't do it, is read some letters to her children that she wrote. Those letters were both an apology for her actions, but also an explanation. And I think more than anything, what those did was help her understand the effects that her actions have on her children and how much they impact them. I've received calls and texts and support from her current boyfriend, who she has one child with, they're expecting her second one. He's committed to her sobriety and sober living. a very good friend who's been helpful in supporting her, giving her rides, making sure she gets where she needs to go. I think all these things show that she's really committed to her recovery. She appreciates, I mean, she's, I think, one of the few drunk driving clients I've had that doesn't complain about the tether, the alcohol tether. What she says is, thank God I have this on because I can't use the Vivitrol. It's really helping me stay sober. The court has the option of sentencing her to some jail time on the child abuse fourth. I think given the progress she's made in her recovery, I think that would be counterproductive. We're asking for a non-custodial sentence on that. If she doesn't continue to make these great efforts, the court can at that time, I think, impose a jail sentence. But I think as long as she's working so hard, I think the court needs to let her continue that.
Anything that you would like to say?
I'm pretty sure that the static saved me and my baby's life. So I just wanted to say thank you for that. I'm really happy that I got caught that day. I'm 85 days sober. I go to a meeting every day. I do everything that I'm supposed to do. And I want to help other women like me once I start going through this program.
I'm sorry, I didn't hear that last sentence.
I just want to help other women like me once I start going through this program.
Well, I'm troubled. I'm going to tell you my negative comments first. One of the things, I've been sitting here for quite a while now, and one of the things that I always think of is how do I say this delicately? It's an impossibility for our society to improve if we don't have parents that care them. Can't do it. Impossible. And I'm not saying every parent, I'm not saying majority of parents, but certainly there's a sufficient amount of parents out there that don't get it. They don't understand. They just don't understand. You can't have parents that don't care about their kids. Because when they don't care about their kids are smarter than we give them credit for, even when they're 2 or 3 and they don't even know that they're thinking. And they know when they're loved and they know when they're not loved. And they know when people care and when people don't care. I'm looking at this from and I told you I'm going to tell you the negatives part first. I'm looking at this and I'm saying, you have a young child in your car, and that child at the time, now you've got 5 kids and you're looking for a 6th, right? Right?
Yes,
And the child that was in the car was how old?
it was 2.
Okay. And you were pregnant when you were doing this, right? On its face, the child has no chance. On its face. No chance. I feel so poorly or badly about the fact that so many kids come into this world and they have no chance because they have parents that are not doing the right things. And I didn't say it's an easy job. I'm not sure any of us are equipped to do it, but it's certainly not an easy job. But we have to try. And we can't have kids when we're doing cocaine and hallucinogens and amphetamines and sedatives and inhalants, and now we're smoking marijuana and we're drinking. All of that, you don't need a legal scholar to tell you that. You don't need a substance abuse counselor to tell you that. You don't need a psychiatrist or psychologist to tell you that. You just need somebody with common sense to tell you. Just a little, they don't have to be overwhelmingly intelligent. Now, that's the bad news, because I'm just really floored by some of the things I read. I really am. We just can't do this. We cannot do this. The good news is, I believe that you're sincere about this. But don't go out of here. I mean, I'm telling you, I'm not saying you're going to be one of them. But I just have sensed, and I can almost see it when they leave the podium. There's either one, boy, I got lucky and I'm going to stick with it, or judge didn't send me to jail. I'm okay. Now I can let my guard down. There can't be any letting of your guard down. If I want you to understand that if you don't comply and make it through sobriety court, you will do a year.
I understand that.
I hope you do, because there will be no ifs, ands, or buts about it. There won't even be a consideration.
I understand.
Now, so far, you've at least weaned yourself off the marijuana. But I'm telling you, nobody can argue with me that alcohol and drugs being consumed by a pregnant woman is anything but horrifically bad for the child. And I don't know how to put it to you this way, but other than saying, I mean, kids are bigger than we are, right? I mean, we should be doing everything we can to make them successful, to make them have values, have integrity, work hard, making them understand the world doesn't owe them a living. I'm going to cut you a break, but I do not want you to walk back from this podium, because there's going to be a lot of requirements here. And I want you to understand, you violate, and you're going to get every single day I can give you.
I understand.
Do we understand that?
I do.
Now, the prosecutor's office, they come out with these things, and they wanted me to send you to jail in so many ways. I'm going to read it to you just to remind you what they said. Sentence agreement of 60 to 90 days is determined by the judge with work release if eligible. May be waived, jail condition may be waived at the discretion of the court if the defendant completes a specialty court program. Court can impose jail at its discretion for child abuse 4. The OWI 3 charges will be dismissed at sentencing. Really, it was an enhanced. It was an enhanced from super drunk, second, which makes it a felony, child occupant less than 16 with a prior, which makes it a felony. So there was no OWI 3, but they were enhanced and they were felonies. 2 years probation sentence agreement with sobriety, drug, veterans, or mental health court that the defendant will need to find placement on or before sentencing. No early termination. 33rd District program is acceptable. We think it's more than that. Full restitution, parenting responsibility should be included. Defendant fails out of the sobriety court or special court due to poor performance, commits another crime while on probation. The judge finds sufficient cause to terminate the balance of the year. 1 year must be served in jail. No work release or waiver. The above are recommendations only is what I made them mad. The court need not order 1 year in jail if the defendant does not successfully complete program. And I've gone round and round with them about that because they're not the judge. And they have the right to do what they want to do and enter in sentence agreements, but I don't have to go along with sentence agreements. I thought that was overly harsh, especially for somebody that might struggle and get to the end and violate, and I'm not giving them a year. But I want there to be no misunderstanding. And I know I'm talking a lot because I'm troubled by this one. I want there to be no misunderstanding. You fall down on this, you're doing a year. Your lawyer has done a tremendous job for you. Did I let everybody finish? I'm ready to sentence if I did.
Yes, thank you.
Anything else?
No, yeah.
I'll get the count. I'm going to call it count 3. It should be child abuse. They're not adding a count. They're reducing a count from operating while impaired second, which is a 1 year, as far as I'm concerned, to child abuse. Fourth, 2 years probation. You cannot leave, but first of all, you have to comply with all agreements, guidelines, and requirements as indicated in the sobriety court participant handbook. 2 years probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs, and you're not to go to any place that sells or dispenses or alcohol. And I'm talking as its primary source of business. I'm not going to consider it a violation if you go into 7-Eleven and buy a Diet Coke, but you're not to go to any bars. You're not to go to parties where alcohol or drugs are being consumed or dispensed. You're to submit the chemical testing, PBTs and ETGs on demand of probation. We're going to pay for those tests as long as you go every single time. And as long as you test negative every single time. You test positive, you're going to end up paying for the test and you're going to be incarcerated. You complete the recommending 60 days. I'm going to make it 90 days on the sober link. I know you have a scram. We're going to change the scram to a sober link. It's going to be on our dime now with our grant. You fail the test, you test positive on a test, you're going to not only be subject to sanctions, you're going to be paying for your own testing for a lengthy period of time. You're to attend 12-step meetings 3 times per week and provide written proof of attendance. You're to obtain an AA-NA sponsor. You're to attend all substance abuse treatment at a facility approved by probation. You're to attend the Victims Impact Panel. That is one night put on by Mothers Against Drunk Drivers. You're to attend and complete the Armed Specialty Court Weekend Program. You're to report to Sobriety Court status review hearings with me every 2 weeks. You're to meet with probation in the off week. You're to obtain and maintain employment with proof provided to the probation department. And this is all on count 1. This is all for the OWI occupant, less than 16, 200 fines, 200 costs, 75 victims' rights fee, $50 justice assessment. So that is 5 and 4. Your screening fee is $60 for 585. You have probation fees of $480, bringing your total to $1,065. You have sobriety court fees of $360, bringing your total to $1,425. Now, I'm going to order that you serve 11 days jail, credit 1. Actually, I'm going to order 15 days jail, credit 1 for 14. I'm going to allow you graciously to serve 10 of those days on the court work program. There is a $35 a day charge for that. You're going to serve the other 4 days by way of community service. You're going to serve 4 days of community service. I'm going to give you time to complete that, and that won't be, I'll give you all the way until May the 31st. You're going to have your hands full. You're to complete 10 days on the court work program and pay a sum of $35 for each day ordered. I'm going to make a note that that is $350 plus your $1,425. So your total here amounts to $1,775. Now, I'm going to talk about court work program fees in a second. All right. Now, if you violate, your probation could be revoked. You could be incarcerated for a year with credit for 1 day served and any other time you serve on the court work program, community service. Defendant not to be completing court work. You're 5.5 months?
7 months.
7 months, I'm sorry. Not to be completing court work not to be completing or starting court work program until at least 3 months after childborn. Your community service, I think you're going to be able to do one way or the other by May the 31. That's not taxing, and I'm not going to have you start on a court work program now. As to count child abuse, I'm simply going to indicate I'm putting you on the sobriety court for that as well. Sobriety court terms and conditions concurrent. This is on, and I want to make sure it's mentioned there, other sobriety court terms and conditions set forth in count 1. to run concurrent. So I'm basically ordering everything on this case that I just ordered on the other one. However, I am going to add a little bit of fines, but not much. Heather, I don't remember. Can you ask Amy? There's one of these, when it's a state case, we don't charge the victim's rights or justice assessment. I can't remember if I charge the 75 or the 50, but not both. So can you check with her if you don't know the answer, or Lisa, please? I'm going to
Yes.
simply go. So I'm not charging any other fees except to say 100 fines, 100 costs. And then you paid the screening fee. You're going to pay everything else. And I will either charge you 75 for the victim's rights or $50 justice assessment. So your total there is either going to be 275.
I'm checking right now.
Take your time, or 250. Again, if you violate, your probation could be revoked. You could be incarcerated for a period of 365 days with 1 day credit. Now, I just want to double check one other thing. They ran Forrest Hughes is who? Boyfriend?
No, he's a friend of mine. He's just a friend. He just helps me out with rides and getting me.
Well, why did we send the victim's rights? He's not the father of any of the children, is he?
No, we were unsure as well. That's why he didn't have anything to say. He didn't know what to say or what to do. And when he called, he couldn't get a hold of anybody around.
All right.
Okay, Judge,
Yeah.
we charged the 50.
So it's $50, something. So it's the $50 judgment fee, justice assessment fee for a total of $250. So you owe $250 plus you owe on this case, and I can't do much better in this $1,775. So you owe $2,025. Now, I'm going to let you pay this case, the child abuse. I'm just going to give you a date of May the 1st. Can you do it by then? That's only $250.
I can do that, Your Honor.
And then I'm going to have you pay, and you can tell me if you can do this, but I need you to stick with it. $50 a week starting May the 8th.
I need you to say that again. I'm sorry.
50 per week beginning May the 8th. Can you do that?
Yes.
Pay 50 per week on count one beginning May the 8th. And if you ever need more time, you need to come talk to me. All amounts due by November 1 of 27. Okay, you have 21 days to appeal, 14 days to apply for a court-appointed lawyer. I'm not taking action on the immobilization since you didn't own the car. There's no evidence that the car owner allowed you to operate while knowing you were intoxicated, and that's what I'm going to do. You'll go meet with probation. We're going to switch out the scram. The judge said switch out the scram for Silverlink, and we're going to have to send a letter to the county because that's where she got it at. Heather, she got the scram tether at the county when the bond was set. Okay.
Okay, Judge.
All right. Thank you very much. Good luck.
Thank you.
Have a good day. Nice day to your counsel.
Thank you, guys. Appreciate it.
Curtis Brent Hamadi, 246R70167. Lieutenant, your name?
Detective Lieutenant Steve Mercury, Rockwood Police.
All right, so this is Judge Hessen's case. She's not here. Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth. So you got it.
I do, Your Honor.
Go ahead.
Your Honor, December 12th, 2025 at approximately 7:08 a.m., officers Christopher LaFleur and Stephen Korn, both with the Rockwood Police Department, was dispatched to the Rebel gas station 22855 Huron River Drive within the city of Rockwood for a panic alarm. Upon arrival, the officers met the cashier identified as Philip Morales. Philip advised that one of his regular customers by the name of Curtis Hamady had come in the store a couple days prior, and when he walked in the store, Philip asked him if him, who was with his girlfriend, asked him if he was ready for the upcoming holidays. The girlfriend replied, "Ho, ho, ho." Philip then told Curtis's girlfriend that she can do whatever she wants in her free time. This comment made Curtis upset, but he immediately left the gas station without incident. On 12/12/25, Curtis came in the gas station, bought 2 large cups of coffee, and as he approached the counter, he got in an argument with Philip over the comment he made about the ho, ho, ho. As the argument escalated, Curtis grabbed the 2 cups of coffee and threw them on Philip, causing coffee to go all over him as well as the store. Philip then at that point said he was going to call the police and hit the panic button. Curtis left the store. Officer Korn reviewed the store video, and it did show that Curtis, who Officer Korn had arrested prior months ago, could identify him as our subject, Curtis Hamady. On 12/12/25 at approximately 8:25 a.m., Curtis Hamady called the Chief Krause of the Rockwood Police Department on a recorded phone line and admitted to the incident at the Rebel gas station. Curtis told the chief that he said he pushed coffee cups that did contain hot coffee towards the Rebel employee. I sent a warrant to the Wayne County Prosecutor's Office, and you have a charging document in front of you.
Based on your sworn testimony, I find the crimes of assault or assault and battery and disturb the peace were committed. There's probable cause to believe the crimes were committed by the defendant and authorize the issuance of the complaint warrant, $200 bond. Maybe you can call them and tell them to come in the warrants, if Mr. Hamady, I'm saying, and just tell him the warrant's going to remain in effect unless and until he does. And I'm signing the complaint and we'll put it in the lien. Okay?
He's on probation through the court also, so.
Okay, thanks.
All
By
right.
the way, I'm changing the date. You sent it over the other day, the 3rd or what have you, and so I'm changing the date on there to the 7th.
Okay, thank you, Your Honor.
Happy New Year, Lieutenant. Have a good day.
Thanks, you do the same.
Harms K. Canoon, 25W840939.
Morning, Your Honor. Paul Yoetz on behalf of Mr. Canoon.
Good morning. How you doing, Mr. Youngs?
Good.
You're going to plead to impeding. You're authorized to enter this plea on his behalf, and they're going to dismiss the speeding, right?
Correct.
To that charge on behalf of Mr. Canoon, to impeding traffic, responsible or not responsible?
Responsible.
Is he licensed here or elsewhere?
Chicago.
What kind of record?
Clean. So what I see in there.
Well, you don't have the Chicago, Illinois record, do you?
No, I keep saying Chicago, but I meant Illinois.
Well, I know.
I believe that we share with Illinois. But no, I don't have his Illinois driver.
150 is the total. Speed's dismissed. You're all set. Does he need some time? Yeah, I'll give him till the 14th. How's that? That's not right. Okay. Thanks a lot. Have a good day. Thank you. Jamela Mebane, MEBANE 22F237322A B and 22R512824A. And also 22R512824B. Who's her lawyer, John?
Oh, Mr. Rickon. Thanks a lot. I'll assume I have no one.
I need him.
Yeah. Well, there is.
All right, I called Mebane here. I have 22F237322A, which is a drive-all license not valid. 22F237322B, which is a civil infraction, improper lights. 22R512824B, which is a failure to pay on a limited access. 22R512824A, which has not been adjudicated. That's a no ops. I hope she has a lot of money. She's been playing games with us. Your appearance? Name, ma'am?
Jamela Mebane.
All right, so what are we gonna do here? She doesn't want to show up, so she's probably gonna have a high cash fine if nothing else. On the no valid license, does she stand mute and wait for a reading? She's only missed about 4 or 5 times on this. And then somebody will be a wise guy and say, oh, you sent somebody to jail on a drive while like, well, I don't know what else to do short of tackling them and bringing them in here. What if she's got others, limited access, $306. Does she stand mute? This is on the limited access from 2022.
I think we got the late travel in pocket for tomorrow. So you'll do it upstairs.
Boy, you don't have much respect for courts, huh?
No, I actually.
Somewhere between 0 and negative 2,852, it looks like to me. I mean, Judge Heston's been overly kind. Okay, shake your head. Judge Heston's been overly kind with you.
Yes. I
Does she stand mute and wait for the reading on the other one?
Yes.
A guilty plea on that. She has Flat Rock in front of Judge Heston, failure to pay. Does she stand mute and wait for a reading on that?
Yes.
Wow. Got a nickel for every time you missed a court date. I could. She doing? What is she doing? Who does she think she is?
I don't live here.
And give a lot of feedback.
Well, good. Hang on. What's wrong with the? What's wrong with the? You live in Toledo. You don't live in Juneau, Alaska. Give me a break.
I lived in Atlanta.
I would quit while I'm behind right now unless you got a lot of money with you right now. Okay? I don't really want to hear it. I don't want to hear it. Tell it to some other judge in some other city in some other state. Where does she work?
Director.
Got a problem.
Makes fun.
She missed April 14th to 22, May 12th to 22. Came in October 12th, or was brought in, I believe. She was given her, or at least it was on Zoom, given another date, January 3, 23. She didn't show up then. She was show caused again in June of 23. She didn't show up then. Wow. And that's just one file. That's just one of the files. I don't feel the need to go through the rest of these. All right, Heather, how much does she owe on all of these? On 224B and, I'm sorry, on 824B and 824, 322A and 322B. I'll set those together.
322A has a balance of 411. 322B has a balance of 248. And then 824B has a balance of 306.
All right, I've got these a little bit mixed up here. I got 824B that has a balance of 306, true?
Yes.
All right. I've got 22F, 237, 322A that has a balance of
411 on that one.
411. She only had 3 files, or she had 4? She has 4, doesn't she?
4 altogether.
Yeah, I don't know what I did with the other one. Hang on a second. Oh, no, I see. And what does she owe on 322B?
248.
Where has she been? Is there any valid excuse whatsoever?
I don't know, but she moved to a in 2022. She came back to me.
Forgot about the meters. Okay. I got it.
He does inform that other than he tests that he has all the criminals. And giving put a that on the file with an updated assessment.
Okay. I'm sorry, Heather. 824A, she owes how much?
824A, that's the one that she hasn't been sentenced on yet.
Oh, that's right. So we're setting a pretrial on you.
Correct, Judge.
Nice. He zoomed in once, so she wants to make it sound like she lives so far away. She zoomed in. She doesn't need to come in here from Atlanta, but all right. I just want to make sure I got these right. She owes 306 and she has a pretrial on a suspend charge. She's missed multiple court dates. The likelihood of her appearing again is not very good. Judging from what I've seen here, it's nearly impossible to rely on. So on 322A, I'm setting, and that'll cover B as well, 600 cash or surety, 600 cash or surety on 824A. 322A and B are covered together. 824A and B are covered together. Pretrial will be tomorrow, January the 8th at 10 o'clock. You'll be in front of Judge Hesson. And that's it. So you're going to have to post $1,200 to secure your release. If you post that, great. If not, you'll be brought over. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Young lady, I don't know what they're thinking, but you need to stop doing this. You don't have the right to do this. Good luck to you. Thank you. J. Javon Maurice Yee Neely Bay, 25F243246A and B and C and
you might need a hieroglyphics translator. So what just made it?
February 4th.
Will that be enough time for you?
I'm sorry.
February 4th.
That would be fine, Judge.
During this matter, February 4th, 2026, 9 a.m. or as your invite indicates, bond will continue.
Thank you for your consideration.
Court calls the case of the people versus Megan Matson.
Your Honor, Michael Vincent on behalf of Ms. Matson.
Hello, your name?
Megan Maxon.
All right.
We are requesting a bench trial at a bench trial date.
All right. Good. Ma'am, you signed this waiver of trial by jury?
Yes, I did.
You understand that you have an absolute and constitutional right to have the matter tried before a jury?
Yes,
You understand that by signing this form, you'll have a trial, but it will be without a jury present.
I do, Your Honor.
People also waive their right?
Yes, Your Honor.
Based upon the statement of counsel, and the defendant court will consent to have the matter tried before it without a jury. Non-jury trial in this matter will be set for.
January 28th at 9 a.m.
Your Honor, I apologize. I'm actually set for a jury trial for Judge Rush Hour on January 28th. Is there?
So you'd rather be there than with me?
I would rather.
No, I'm just saying you were assigned to this courtroom, and so you're telling me that you're going to be somewhere else with a judge that you like better. Is that what you're saying, Mr. Cook? I'll wait for your answer.
Your Honor, we'll waive his appearance. Okay?
Can you give me another date? Since Mr. Cook likes Judge Fresh Hour better. Well, I like Judge Fresh Hour better.
The next is February 25th.
I will be out of state, I believe, at that time.
No, it's not Christmas. You won't be anywhere. Is he gone?
Fortunately, well, no, actually, yes.
He is? Fine. So he'll be out of state. Cook likes Fresh Hour. Go ahead, give me another day. We'll try to fit it into all their schedules.
The next date is March 25th at 9 a.m.
Is that okay?
That works for the time.
Okay, of course. Nobody has anything on their schedule. Well, hey, can you be here, Mr. Cook?
The trial's out that far, so I shouldn't be free.
Non-jury trial, March what?
25th, 9 a.m.
25th, 2026, 9 a.m. Bond will continue.
Thank you.
We'll see you in a quarter of a year. All right. Take care. Court calls the case, people versus Albert Wilson.
Good morning, Your Honor. William Amadeo, P7619. Probably
I didn't see you over there.
I'm sorry, Judge.
No, I would have.
Been working out, losing some weight. I hope this helped pay it off. Mr. Wilson, please state your name for the court. Say your name for the court, Al.
I'm sorry to
Say your name.
Oh, my name is Elvin George Wilson.
All right, very good. All right, where are we on this?
Judge, Mr. Cook is now the prosecutor on the case. He did provide a potential offer.
Until he decides to go to another court. But go ahead. No, never mind. My bad.
With that being said, my client is 77 and I'm not sure he could do sobriety court and make it there. So I'm trying to come up with an alternative, maybe community service. I'm trying to keep him out of jail, obviously. I think we're close to resolution,
Okay,
but he's not able to drive. So I'm trying to make sure I don't set him up for failure.
okay. So you need an adjournment.
Like 3 weeks if I could.
My next date,
It'll be February 4th at 9 a.m.
will that work?
Yeah, thank you, Judge.
Adjourn the matter to February 4th, 2026, 9 a.m. Bond with its conditions will continue.
Thank you, Judge. Good
All
seeing you.
right, thank you. Good seeing you, sir. Court does call the case of the people versus Elizabeth Raggett.
Morning, Your Honor. Raymond Cook with the people. Morning, Your Honor. Sam Bernstein with on behalf of Ms. Raggett. Ms. Raggett, can you please say your name?
Elizabeth Raggett.
All right. Morning.
We're just waiting on some information from the prosecution, Your Honor, and they're going to be sending that our way. So hoping for an adjournment.
In the matter, February 4th, 2025, 9 a.m. That'll work for you?
Yes, Your Honor. Thank you.
All right, thank you. Thank you, Ms. Raggett. Court calls case, people versus Austin Shepherd.
Morning, Your Honor. Raymond Cook for the people. Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Shepherd, who I see on the Zoom screen.
Yes, Your Honor.
All right, state your name, please.
Austin Shepherd.
Okay, I'll excuse it this time. Next time, put on a shirt.
Oh, I'm sorry.
Enjoy.
I'm hoping to adjourn for a potential resolution, Your Honor. Mr. Cook had talked to me about that a little bit this morning. I want to follow up.
February 4th,
Yes, Your Honor. Thank you.
2026, 9 a.m. Bond continued.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, sir. Court calls case, people versus Brandon.
Curacoso, Your Honor.
You know, I was gonna get it.
You were
I
good
just
last
had to break apart the syllables. So it's Curacoso.
Your Honor, good morning, ma'am. Please the court. James W. Murray, P 48047 on behalf of defendant. Please state your full name.
Brandon Curiacosa? That's exactly what I said. Wasn't it, Alan? All right, because you gave me the pronunciation. I appreciate it. Go ahead.
If I may, Your Honor. So Mr. Cook needs to review the video on this case, which I believe is dispositive of the whole matter. I'll resist telling you what I think happened.
I figured that would be the case. February 4th, will that work for you?
It will. Is this a 9 a.m. case?
Well, I said everything at 9 a.m. and then what I do is they're divided into blocks and typically private counsel would be early in the morning.
Okay,
All right.
very nice.
February 4th, 2026, 9 a.m.
Your Honor, it's nice seeing you and thank you.
Good seeing you, sir.
Okay.
All right, thank you, sir. Court calls case, people versus Hassan Issa.
Raymond Cook for the people.
That name I got right. Because it's four letters and really only three. So.
Good morning, Judge Hugo J. Mack, appearing with Mr. Issa. Please state your name for the record.
Hassan Issa. Thank you, sir.
Your Honor, we've discussed matter with the prosecutor. Believe we do.
How'd that go?
It went well.
Did it?
It went very well. Thank you so
Be
much.
asking Mr. Cook, how did it go? But anyway, go ahead. What do we do?
Be very well. Does the court have a copy of the Secretary of State return? And if so, does that show that its license is valid?
If not, I've got a picture of his license here.
I couldn't even answer the question.
Well, no, I'm always trying to.
You're gonna try to show me a picture.
No, not me, Jeff.
You know, it's so funny. Mr. Cook was asking me for the official, report of a document. Hugo Mack, I got a picture, man. His license is valid.
It's a beautiful thing, Jack.
It is. This case is dismissed. All right. Thank you, sir.
Thank you so much. Appreciate you.
Take
Appreciate
care.
Congratulations, Jason. Thank you. Sure.
Boy, now there's gonna be no controlling Hugo. He got it.
Judge, I can still hear that.
Oh, sorry. I thought I was whispering. Court calls the case. People versus Edgar is it Constantine?
Ready, Your Honor? Edgar Castellanos.
Yes, that's what I meant to say. All right.
Good morning, Your Honor. Julian Poot on behalf of the defendant, Edgar Castellanos.
Right, and this is an arraignment. Count it, folks. You just have it as a pretrial. I don't see any arraignment information. He was not arraigned. Counsel, as to the arraignment, you waive formal reading, your client stands mute.
Yes, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. All right, and what are we doing on this today?
Your Honor, I'm asking if we could have the matter set for a final settlement conference and trial date.
Sure, we can do that. Jury final settlement conference in this matter will be set for February 6th, 2026 at 9 a.m. Jury selection, if necessary, will be February 9th, 2026, 8:30. Both of those proceedings are in person. I will set the defendant's bond in this case in an amount of $5,000 personal recognizance. I'll order standard conditions, including no assaultive behavior, possession of any weapons. There's to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. You understand that, sir?
Yes, sir.
And does the defendant have any other alcohol-related offenses in his past?
I don't believe so, but let me double check.
I see what now you're under no objection to
No, Your Honor, this is the only.
No? Okay, then I won't order testing. I'll just order those conditions. All right? Thank you, folks.
Your Honor, I do have a conflict on February 6th. Is it possible to have it at 10 o'clock instead of 9?
If you let us know that you're showing up at that time, but I set all of those final settlement conferences at 9.
That's fine.
If you just make sure my office is contacted, letting us know that you'll be delayed about an hour, then we'll work with you.
Thank you.
All right, thank you. Court calls the case of the People versus Zeke Church.
Morning, Your Honor. Judge, good morning to you and the staff. Vincent Haysha, with and on behalf of Zeke Church, who's present through Zoom, obviously without objection.
Did I say Zeke? Yeah, I did. Yeah. Zeke
Oh,
Church.
good, Judge.
All right.
New year.
State your name, sir. Zeke Church. Thank you. It's going to be a day. All right, what are we doing?
If I could, Judge, Mr. Cook and I have been in contact. We're exploring ways to resolve this. I think probably best at this point to set for final pretrial jury selection, see where we're at. We may resolve, we may not. We'll see.
Jury final settlement conference will be February 6th, 2026, 9 a.m. Jury selection, February 9th, 2026 at 8:30. Both of those proceedings are in person.
That works, Your Honor.
And when you show up in person, I will get your name right. All right. Thank you, sir.
Thanks, Judge.
All right. Court calls the case, People versus Joseph Crossley.
Morning, Your Honor.
Good morning, Judge Lawrence H. Margolis with and on behalf of Mr. Crossley. Joe, please unmute yourself and state your name.
Joseph Crossley. What are we doing?
We'd like this set for a final settlement conference and jury trial, Judge.
Jury final settlement conference will be set February 6th, 2026, 9 a.m. Jury selection in this matter, February 9th, 2026, 8:30. Both of those proceedings are in person. Bond with its conditions will continue.
Thank you, Judge.
Thank you. Court calls the case, People versus Adib Shawaka.
Lawrence Margolis on behalf of Mr. Shawaka, please unmute yourself and state your name, sir.
Yeah, Adib Shawaka.
You need to put your chain in, please.
Yes, sir.
Similar.
What are you doing?
Similar to the last case, Judge, please have this set for a final settlement conference and jury selection.
Jury selection or jury final settlement conference, February 6, 2026, 9 a.m. Jury selection if necessary, February 9th, 2026, 8:30. Both of those proceedings are in person. Bond will continue with its conditions.
Thank you, Judge. Have a good day.
Thank you. You do the same. Court does call the case of the people versus Jamonte Love.
Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Shauna Basti on behalf of Jamonte Love. Mr. Love, state your name for the record.
Jamonte Love.
Thank you. All right, what are we doing? Don't everybody speak up at once.
I believe we reached an agreement on this one. I apologize. I have a complete form here physically. I was unaware the counsel was appearing via Zoom. I can get a digital copy over to defense counsel for signature if the court wouldn't mind passing this. I apologize.
So it's a guilty plea of some type?
Correct.
All right, so what I'll do is, because she's gonna have to get it to Mr. Love. I can do it one of two ways. I can adjourn it out or I can call it up in the next block. Can I fit it into the next block? Yeah. I can call it up in the next block at 10.
I'm fine with either of those, whichever works best for defense counsel. I don't know if she has other hearings this morning that.
Counsel, which would you like us to do?
Mr. Love, can you, are you able to sign this document so you can take your plea today?
Yeah, you're gonna send it to me and I just gotta print it?
Yes.
Yes, I can do that.
All right, so what I'll do is I'll just pass this, let you guys work out the logistics during my break, and then I'll call it up in the next block, all right?
Thank you.
Perfect. Thank you, Your Honor.
Thank you. Court calls the case, People versus Marcus Stewart.
People.
Good morning, Your Honor. Tia Brock on behalf of Mr. Stewart, who is present via Zoom. Mr. Stewart, please unmute and state your full name for the record.
I see his name there, but.
I did see him as well.
Marcus Stewart. Thank you. You'll need to be someplace stationary, sir. All right,
sorry.
What are we doing on this?
We'd ask the court for a final pretrial date and set for a jury trial as well.
Jury final settlement conference will be set for February 6, 2026, 9 a.m. Jury selection, if necessary, February 9, 2026 at 8:30. Both of those proceedings are in person. All right, bond will continue. Thank you.
Perfect. Thank you. Have a good day, everyone.
All right, you do the same. And that's it for that block? All right, court will stand in recess. Rise.
Two five F 243-946. Where's this gentleman at? Or Jawan Neely? Any idea, John? Madison Molinari. Madison Gabrielle Molinari, shoe 4W8355562. Good morning, ma'am. Your name?
Madison Molinari.
All right. You didn't check in with the prosecutor yet, right?
No, I did not.
So this is a review hearing.
Neely's in the courtroom, you know.
Where's she at?
Ready.
Why didn't you come up here when I called your case?
You said my brother, you said J1. I'm Jemiah.
Well, I mean, I can't have you represent. Hang on. Hang on. Okay, so on review hearings, John, we got to send them over to the prosecutor.
Yeah.
Is he in what? Is he at 249?
Yes.
Just get here.
Your Honor?
Yeah, real quick on this Molinari, it's just a review hearing. I'm going to ask you to take a look at this. We should have had this into you before. My apologies.
No worries.
Thank you. John has it. Thanks. Ma'am, you go meet with the prosecutor and then you'll come back in here, okay? I don't understand. Is Jay Jawan, are you Jay Jawan?
Yeah, that's my brother.
Well, where's Jay Jawan? She said.
Yeah.
Are you here? You're not trying to represent him or anything?
No.
I have two names. I had that one. I have.
They must have pulled the wrong file. Here, where's Molinari? Give Molinari to Bill, will you?
Hang on, Bill. Hang on. Sure.
We might have pulled the wrong file here, Heather.
Bill. Well, this is Matthew. So that's Mr.
Judge, we do have Jay Jawan under the 840s today, but we also have Janaya on too. We have a lot of G. Neelys on the docket today.
I see.
Steve, Janaya?
Yeah.
Yeah, so these are not the right files. Charles Lester Laney, 25W39812.
Good morning, Judge. As I get to come back from Mr. Neely. Ladies, I apologize. I got caught up with the whole thing.
I can't.
Mr. Lane, state your full name.
Charles.
I'm not gonna adjourn this again.
Your Honor, may counsel and I approach
Your appearance.
briefly. William, you're a county city Whitney.
Why wasn't he here December 10th?
Judge, that was on me. There was confusion as to whether or not.
How was there confusion?
Well, Judge, I was retained on this case way back in September. Originally, they had assigned Mr. Laney to my brother, who was also an attorney, Judge. And the notices were going to him.
Guys, I can't keep adjourning these.
This would be a last, may we approach, Joe?
It's 100 days old already.
I understand, Judge.
Very quickly.
Judge, I don't want to end so.
Hang on a second. Okay. John, go off YouTube a sec. Go off the record, please.
Yeah, it's
Scene and does he stand mute and waive formal reading?
He does, Your Honor.
I'm going to enact guilty plea $500 personal bond. Sir, you cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. Does he still live on Colonial Drive?
He does.
All right, so that's where we'll send the notice, but we'll give you a new date right now. And what date do you have for me, Heather?
It'll be February 4th at 8:45.
February 4th at 8:45.
That's
Okay?
perfect.
All right, so we'll see you then. Anything else you need to bring up?
No, we have discovery order was entered. We've had some discovery, but need to do some additional. So.
Good enough.
and
Have a good day. Happy New Year to both of you.
Thank you. You as well.
Thank you. Okay, what else do I have down there? People against. Michael Alexander Pina. 2523W8322821. You're another one, Mr. Pina. Pena, I don't know what your name is, sir. Come on up here, state your name.
How you doing, Your Honor? My name is Michael. I've been detained.
Where you been?
Good, and you? I'm here today because.
No, where have you been? You were supposed to be here in front of her. I'm back on December of 23.
Exactly.
That's 2 years. That's 25 months. Where have you been?
Correct. I am under the impression somebody may have used my name. This is my vehicle, correct? But a police officer let me know that I had a warrant, and don't even remember being out. So yes, I could have let somebody use my vehicle at the time. But I do not recall at all being pulled over.
So you're charged with failure to pay $248. Is that the amount, Heather?
Yes, it is, Judge.
So you could be held in contempt. I'm just telling you the possible penalties. Now I'm gonna make a suggestion. Up to 1 day for every $10 owed, you could get 25 days. You can satisfy this in full by payment, full by serving a jail term, or in part by payment, and in part by serving a jail term. Do you understand that?
Say that one more time. You said that a little bit ago.
I'm sorry. You could get 25 days. If you pay $148 as an example, you'd only owe 100. You'd only have to serve 10 days. You can satisfy this contempt charge by paying it in full, by serving 25 days, or any combination thereof. Do you understand that?
I understand.
Did you sign an advice of rights form today and read it and understand it?
They're signing in today.
All right. You're presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to question their witnesses, to bring in your own, to use the subpoena powers to court, to bring in those witnesses, to testify or remain silent. If you remain silent, that silence will not be held against you. If you plead guilty, you give up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Right.
You have the right to a lawyer. If you want one, I will give you one. If you want a lawyer.
Court planning.
You look?
Yeah.
Where at?
Jail.
I'm sorry?
It's a plant in Pontiac. It's called Jail. Corporate.
How much do you make there?
About 1,200 every week.
Every 2 weeks?
Yeah.
I'm going to enter a not guilty plea. Did you live on Ken Cross Ridge in Greenville, South Carolina?
Correct.
Were you living there in July of 23?
No, I believe I got that right.
Well, when did you get back?
Not sure. It was 23 though. Might have been in the summertime. It was warm outside still on Saturday.
I'll give you a $500 personal bond. We're going to schedule this for hearing in front of Judge Hessen. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Do you understand all that?
Correct.
He's to fill out a petition for a court-appointed lawyer. You are going to get a hearing date. I want the officer here, issuing officer, to appear. And we'll have a lawyer for you. So fill out a petition. We'll get the officer to appear at a later date. You show up at the later date, and we'll give you a lawyer.
Okay.
Okay. What do you have for me, Heather? This is Judge Hessen's.
All right, let me take a look here, Judge. We could do, you want to do it on the Woodhaven day? She has Woodhaven next Wednesday.
That's fine, whatever you think. You want me to set it for that day?
Yeah, we could do the 14th. Let me take a look at her schedule at 9:30.
Okay, so next week at 9:30, okay? All right, so go down the hall, get your notice, but before that, fill out your petition for a court-appointed lawyer. Okay? Any questions?
Okay.
All right, and if I'd search my memory and decide what I'm gonna do there, right? But you can talk to your lawyer. Good luck. Kevin Hudson Sterling. 25W39175.
Good morning, Judge and staff. John Graziani appearing on behalf of Kevin Sterling, P numbers 43387. Please identify yourself, sir. Kevin Sterling, good morning, Your Honor.
Good morning to you. I don't think I ever signed the summons here, so I'm signing it today. All right. So what have I got here?
This is a fraud, Judge.
Does he have any criminal history?
He does not have any criminal history, Judge.
Okay, so for purposes of arraignment, does he stay in mute, wait for
Yes,
the reading?
we do, Judge.
I'll enter a not guilty plea, and then, as I understand it, he's going to plead guilty. There's going to be restitution on a 48236, and the agreement is that the prosecutor will take this or ask the court to take it under 771.1 for a period of 12 to 18 months. True?
That's correct, Judge.
All right. Is that what you want to do, sir?
Yes.
If you plead guilty here, possible penalties on this are up to 500 fines. 93 days jail. Costs are all of those. I'll place you on probation at some point, set terms and conditions. We do have to notify the victim. They still have the right to appear. If you're compliant during the period of probation that I set, then at the end of that period of time, the case will be dismissed. Can't really do it for 18 months. You know, the maximum really on a 771 is 12.
We just wanted to exhibit good faith, Judge, and that's why we.
No, I understand, but that's good. That's fine. I got it. So do you understand all that?
Yes, or not.
And did you sign
Judge, I explained the advice of rights, but he did not sign.
Yeah, I need you guys to have them sign these if you would, please. All right. All right. All right. Are you satisfied with everything, Mr.
I am satisfied, Judge. We'll also rely upon the police report.
All right.
Basis. Thank you, sir.
All right. Do you understand everything on those advisory rights? I can't hear.
Yes, sir.
Did you sign it, read it, and understand it?
Yes.
If you plead guilty, you will be giving up all those rights, and we are not going to have a trial of any kind. Do you understand that?
Yes.
All right. Any questions before I ask you how you plead?
Yeah, Your Honor.
To the charge of retail fraud, how do you plead?
Guilty.
Was this over a period of dates?
It was over a period of dates, Judge, and he confirmed what happened in the report, so we could rely on that.
So between May 1 of 25
in October, I believe, Judge, or a number of incidents in that report.
and October 27 of 25, were you at the Aldi's? I got to have you keep your voice in.
Yes, sir.
Did you take property offered for sale without paying for it?
Yes, sir.
Was the store open to the public?
Yes, sir.
Did you walk past the register with the intent to steal the property?
Yes, sir.
And was the property at least valued at $482.36?
$82. Yes, sir.
Anybody forced you to plead guilty?
No.
And that was at Aldi's in Woodhaven at 20078 West Road, correct? Are you on probation or parole?
No, Your Honor.
Anybody in the world force you to plead guilty?
Courtroom.
Okay, I'm going to accept your plea. I find it to be an accurate plea made voluntarily and understandingly. The plea is accepted. I'll take it under section 771.1. I'm going to give you a $1,500 personal bond, and here are your bond conditions. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No contact with Gregory Mulford or employees of the Woodhaven Aldi. You cannot write, phone, see, text, email them, communicate with them, or have anybody else do any of those things for you on their behalf. Nor can you have any contact with prosecution witnesses except through your lawyer. You're not to enter the property address of 20078 Weston Woodhaven. You are required to go to Woodhaven Police Department and be photographed by January 7th at noon. Was there any drugs involved?
None, Judge. There's no drugs or alcohol involved. This is.
Okay. Pre-sentence report and sentence date. We're going to give you a sentence date. You're going to go down the hall, pick up that date, the notice. You're going to get a copy of the order for prints. You're going to get a copy of the bond sheet. and then you're going over to probation where you'll be interviewed, and then you're going over to Woodhaven by noon today to get photographed and fingerprinted. Do you understand all that?
Yes, Your Honor.
Okay. So what do you have for a sentence date for me?
It'll be February 4th at 8:30.
Is that good with you?
Judge, that would be fine.
He doesn't want to do the court to school, does he?
No, Judge, this has been a very.
Okay, good enough. February 4th at 8:30.
Thank you.
All right, you understand everything?
Yes, Your Honor.
Does he work?
He does work right now, right now he's on a disability, short-term disability, Judge.
Okay. All right, so we'll see you back here. I wish you well. Any questions?
No questions, Judge. Thank you again.
Have a good day, Mr. President. Thank you. Eon Michael Evans.
It's my understanding that we talked to the brother and that he is not interested in having Ms. O'Leary come live there. And we have not been able to find her housing at the Coach or Mindful Healing.
That is my understanding from the recommendation with Officer Rose. It would be her recommendation that the housing would be provided by the Hope House and continued treatment could be provided through MPW if placed there.
Ms. O'Leary, I want to get you out of the jail, but I don't have a place to send you.
I could talk to my boyfriend. I mean, he rents property. So he's just waiting for a place. He's got them all rented. He's working on one now. Just ain't got no running water.
All right. Well, let's go with the Hope House option, and then we can explore, as we get a little farther into this, how that's going to work. So I previously found that you'd waived your right to be represented by a lawyer and admitted this violation. I'm going to continue you on probation, and we'll release you on GPS to the Hope House, get you into the treatment. As soon as you can get a stable residence. I mean, the Hope House is a very short-term program. Get a residence, get your treatment done, get out.
All right. Thank you.
All right. Anything else?
No, Your Honor.
All right. That's all.
Thank you.
Five. 24W836-404.
Ian Adams.
Is he in custody?
Yes. Okay.
I don't understand these guys. All you gotta do is come talk to us. All right, detective, your name?
Detective Davis, Woodhaven Police Department.
Mr. Evans, your name?
Ian Evans.
Your appearance?
I would expect Ian Adams.
What is he gonna do?
Judge, he works for 4 and gets paid Friday and can have this paid by Monday. But he will plead guilty to felony.
Hang on, look at me, Mr. Williams. You understand what your lawyer said? Hello? Talk to me, not to him. He's the police officer. I'm the judge. Come on up here. Are we having a problem with the volume?
A little bit. I didn't tell you were talking to me. My fault, sir.
All right, that's all right. Can you hear me now?
Yeah, I can hear you.
Your lawyer tells me you're going to plead guilty. If you plead guilty to this failure to pay $285, you could get 29 days. You can satisfy that in full by serving the 29 days, so you'll be out by February the 4th or 5th, or you can pay it all, or you can serve some time and pay the balance. You get $10 credit for each day served. Do you understand that?
Right.
I can't. You understand that?
Yeah.
You're presumed innocent. They have to prove you guilty by preponderance of the evidence. You have the right to question their witnesses. Bring in your own. Use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and we are not going to have a trial of any kind. You understand that?
Yes, sir.
To the charge you failed to pay $285, how do you plead?
Plead guilty.
You failed to pay?
His balance is actually $320 now.
Oh, $320 because of warrant fees, because he doesn't show up. To the charge you failed to pay $320, how do you plead?
Guilty.
So you could get 32 days. Do you understand that?
I do, sir.
You failed to pay?
I cannot pay right now. I'm sorry.
Did you fail to pay? You got a problem.
I did fail to pay.
Anybody force you to plead guilty?
Nobody forced me to plead guilty.
How old are you?
How old am I? 22. Just turned 22.
You work at Ford Motor Company?
A little over a year now.
Where at? Which plant?
Down in Monroe, the packaging plant.
How much do you make there?
I just now make over like $25 an hour.
You married?
No.
Kids?
I have a kid on the way in April.
You're making $25 an hour and you haven't paid your fines? You got a big problem here. You better call somebody.
Yeah, it was.
You don't think I'm going to let you walk out of here today, do you? You show disrespect like this, you don't pay.
I know.
Hang on. If you told me you were making $8 an hour and you had 4 kids and somehow, some way you didn't have the time to come in here, I might understand it. You should have come in and talked to us. You didn't show up in March. You blew this off. Yeah. Did you let him make detective your name?
Detective Kyle Davis.
Did you let him make calls?
He did get a phone call with his mother, I believe, hours ago.
You better get your mother to bring you the money.
Yeah, I already, it's all my money, and I pay rent and stuff on my own, so I don't get paid. I don't get paid until Friday.
Rent to who?
Rent. I pay for my own house and stuff, so I
you own a, listen, do you rent a house?
I do.
Where's the house?
That's over there in Taylor.
How much you pay per month?
Just about $1,500, a little bit more. Like I wish I had the money. I would pay it right now if I could. Like I said,
it's not that you don't have the money. That's not the issue. The issue is you should have shown up for your show calls and said,
here's the thing,
hey, listen, you're interrupting. Judges don't like it when you interrupt. You should have just come in here back in March and said, Judge, listen, I'm having some hard time. I pay $1,500 a month. I don't have the money. Can I have an extension? In which case I would have said yes. And if you did that, you're interrupting me again. I thought I said not to interrupt me. If you did that 42 times, I still would have let you go on. Do you understand?
Yes, sir. I understand. Can I add something, Your Honor?
Can you have what?
Can I add something? I haven't the reason why I haven't had no vehicle though. So ever since
wait a minute, I didn't hear that. You what?
I haven't since I got that accident though. I never even knew that I never had no vehicle to get that ticket or warrant handled. So I never even knew that it became a warrant until I had my new vehicle set. So it's kind of I didn't avoid it. I just could never make my way down to Woodhaven or anything like that to
Hey, that sound like you live in Iron Mountain, young man. You drove by here every day. Where's the plant you work at?
I technically don't drive there. I drive.
Where's the plant you work at?
Monroe.
Where's Taylor? Is it north of here or south of here?
It is. That's north from Monroe.
Where is Monroe from here? Is it south of here or north of here?
South.
You drive by here, whether you're driving whether you're taking a helicopter ride, a boat ride, you're taking a bicycle, somebody's driving you. You come by here every single day. I-75, you would take to Monroe, and there's a Woodhaven exit on I-70 off of I-75.
Yeah,
Make it sound like this was an impossible task. We didn't ask you to go to the moon.
Yeah, I'm sorry. It was real.
It's not. You don't have to apologize to me. You're going to be the one that's going to end up with the consequences here.
I know. It's just things. Like I said, when I got that ticket, I didn't. I lost my car. I was in the middle of moving, and I never even really thought of it. And then I got a car back, and then the car blew up on me, and then I had to get a new. It's just been it's not even I don't even drive to work. To be honest with you, my mom drives me to work. So, I carpool with her. We work together. So, it's not that I purposely avoided or, it's just I just never even really had thought of it. I ended up moving. I never got an email or text that the ticket became a warrant or anything like that. So, and
where was it? Hang on, slow down. Detective, where was he picked up?
Southgate.
What was he doing in Southgate?
It was a traffic stop. The officer indicated that the high beams were on, so he pulled him over because the high beams and
I
windows.
thought you just told me you don't drive. Didn't you just tell me, hang on.
I said, I don't drive.
Hang on.
I don't go down past Woodhaven. I go to reviews of the gym and that's it.
You drive to Monroe for work, right? Somebody drives. You don't take a helicopter, do you?
My mom, yeah, I drive my mom down there, but I ride back here up to Taylor after work and then I go to the gym. I go to the gym.
The more we're having this conversation, the more I think you need to go to jail.
Okay.
These guys. How much do you get paid on Friday?
I should get paid around, it's a holiday check. I should be getting paid pretty good money.
I didn't ask you that. Can you pay this all on Friday or do you need more time?
I can pay it all on Friday, sir.
Are you sure?
100%.
I will give you more time if you need more time, but you can't do this. You should learn that this should be a lesson because really you should go to jail today. Are you sure you can pay all of this on Friday?
The 300 and what is it, $20 now? I can give you even more than that.
I don't want more than that. You pay $320 by January the 9th. Actually, I'll give you credit. When was he picked up? This morning or yesterday?
This morning at 2:20 in the morning.
Well, he spent some time in jail. You pay $310 by January the 9th. Any balance waived? There is no balance because I'm giving you $10 credit for the last few hours. Come on, don't get in the habit of a lot of these other guys, will you? You're going to just make your life miserable.
I know.
Not enough without doing that. Judges are not unreasonable. You go talk to them. Judge, I don't have the money. Nobody's going to give you a hard time as long as you go in there and are up front. You're not brought in handcuffs. Best of luck. Thanks, Detective. Jonathan Glenn Compton.
I'm sorry,
What's
Judge.
that?
I missed the date it cut out that you gave him.
He's going to pay by the 9th, Friday.
Okay, perfect. Thank you.
Thanks. Jonathan Glenn Compton. 25W839357. Is Mr. Compton here?
He's coming in right now, Judge. He's on Zoom.
Okay. Mr. Compton, you have to start your video, unmute, and state your name, please. Who has Mr. Towns? I need somebody with Mr. Kerman. Can you call Mr. Kerman wherever he is and tell him I need him in here on Mr. Is Mr. Towns in here?
Yeah.
Go get your lawyer. Tell him I'm ready, okay? Mr. Compton, your name?
Jonathan Compton.
All right, this is an older case. Well, no, it isn't. It's a retail fraud case. You have the right to an attorney. Would you like an attorney to represent you? You're charged with retail fraud. Today is the date scheduled for arraignment and pretrial. Do you want a lawyer?
Yes, sir.
All right, good enough. I'm going to give you a lawyer. We're going to put you in a breakout room, whoever that is, Heather. And you'll speak to the lawyer and then you'll come back in front of me. Okay?
Okay.
Thank you very much.
Thank you.
People against Laney. Charles Lester Laney, 25W839811A and B and C and 25W839812.
Good morning, Judge. I have a bit pretty much Mr. Meetings, my state plan.
All right, so this is going to be a bench trial, right?
Correct.
Is that what you want to do, Mr. Laney?
Yes.
You have the constitutional right to a jury trial. By waiving a right to a jury, I will be the one who will solely decide your guilt or innocence. Do you understand that? 6 people will be in panel. All 6 would have to agree that you're guilty beyond a reasonable doubt in order for you to be convicted. Do you understand that? Yes. Anybody forced you to give up your right to a jury trial? And you still wish to do that? All right, I'll accept the waiver. And we'll have a formal hearing on the other 2, the civil infractions, on that date. Are we going to be able to do this? Now I've got to go further, right? Is this going to be a plea or something, do you think?
Hopefully, Judge, we're looking at a resolution here, yes.
Heather, I don't want to have to move all this. I'm already on the board on this or soon. Do I have to move this all the way to February?
For a jury date, Judge? Is that what
No,
we're
just a
looking at?
bench.
Oh,
just a
yeah, for
bench
bench
trial.
trial.
I'm off on the 21st.
Yes. I talked to Mr. Yurick about the 28th and having an afternoon docket, but I have not heard back yet on that.
Is he good with that date?
January 28th?
Yeah.
Great, are you good with January 28th?
No, I mean, did you talk to Mr. Yurick about that?
We did not discuss a date. We thought, Judge, you were gonna push it out to the 21st.
I was, but I'm not here.
Okay, I can go, I can. Running that.
No.
Your Honor,
Are you good on January 28th at 1 PM for a bench trial on this?
I am going to, that would be for Mr. Fanego, so I would have to check that, Judge.
Can you check now?
I can check now. I can't guarantee a response now, but I will certainly check now.
I'm curious what.
I will come in with
Fine.
the information as quickly as I can. If you could pass the matter.
I'll pass it. Thanks.
Thank you.
Bye. All right. Have a seat 1 second, okay? As soon as he comes in. Charles Lamont Towns. 25W839-232 OM. You find him, Mr. Towns?
No, also looking for.
Shaquila Shante Harvey. 25 W838266A and B. Your name? You're another one. You are another one. You had a ticket on the A file. It looks like you posted a bond on that and a bond on B. Did you talk to the prosecutor yet?
Yes.
Okay. Did you have a lawyer?
No.
All right, so you're going to plead guilty to allowing an unlicensed driver to drive, right?
Yes.
If you plead guilty to allowing an unlicensed driver to drive, possible penalties are up to 500 fines, 90 days jail, costs, or all those. Do you understand that? Did you sign, read, and understand the advice of rights? If you plead guilty, you will be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yeah.
So he's also going to dismiss the suspend and the no insurance, right? All right. Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a trial. Do you understand that? You have the right to a lawyer. If you want one, I'll give you one still. Do you want a lawyer?
No.
To the charge of allowing an unlicensed driver to drive, how do you plead? Were you in control of a 2017 Chevy that was being operated on Western Ford Lane in Woodhaven, April 3 of 25 at 1:52 in the morning?
Yes.
Allow somebody to drive that was unlicensed, and that was you, correct? Are you on probation or parole?
No.
Anybody forced you to plead guilty?
No.
Please accepted. Where's Kyle Robinson? Is he gonna let you apply the bond?
Yes.
You're gonna have to call him and have him call the court. What's his relationship with you?
My husband.
You go out the hallway, call him. I'll accept your plea. I'll dismiss the suspend. I'll dismiss the no insurance. Where does he work?
Yeah, it's in John.
How do you want me to handle this, Heather?
As far as the bond judge, he can
What's in her
call up,
husband's name?
he can call up and ask for the cashier, Stephanie, and Steph will talk to him and she can get his permission.
All right. So I'm gonna have you call him and then he's gonna call, right? I'm gonna write it down for you. Okay? And he can call our cashier and tell us, and then you're gonna come back in here and I'll send you. What's Stephanie's extension?
I believe it's, let me double check here, 212.
Come on up here. My recorder's going to hand you this sticky note. And you can call your husband right now, not from the courtroom, go out in the hallway. Call him and tell him that, ask him if he's going to allow you to apply the bond, assuming he is. You're coming back in here and I'm going to sentence you, okay? Thank you very much. I'm still waiting on Mr. Carmen, right? Thornsberry, Johnny Luke Thornsberry, 25W839-358. Mr. Carmen, I'm going to need you in the courtroom, sir.
Be right in.
Your name, sir?
Johnny Luke Thornsberry.
You're charged with possession of LSD, it says, possession of cocaine, Schedule 2. Do you have the right to a lawyer? I'll be happy to give you one. Would you like a lawyer?
It's LS. I didn't hear no LS.
And when you look on the bottom, it says possession of cocaine. I don't know why you came up with LSD.
Oh, okay.
So hang on. Don't tell me you had anything. Don't admit to anything right now. I'll give you a lawyer and you talk to your lawyer and you can explain all that to your lawyer. Okay?
Okay.
And then come on back in here as soon as you and your lawyer have talked. All right? Thank you very much. People against Charles Lamont Towns, 25W839-232. Come on up to the podium, sir. State your name.
Charles Towns.
All right.
No. Mr. Is it Zoo?
Mr. Zoo. Mr. Zoo is.
I mean, I think I read some stuff in there that basically said, hey, can you help us out with this? And your people are saying, no, we will not. How do we get around that?
Mr. Zoo is a non-party who we don't have control of. We agreed prior to your November 12th order to try to coordinate his deposition. That was first set in March, but then canceled. Then I think after your order, it was noticed for November 21st or 24th. We were working with our client to contact Mr. Zoo about his availability, and we were prepared to go forward with the notice deposition. After your order, Mr. Dunn reached out and asked to reschedule that deposition on the afternoon of November 19th. This isn't reflected in the written record, but he reached out to reschedule. We reached out to our client the next day. The only means we had to contact Mr. Zoo, asking him to contact Mr. Zoo about these potential alternative dates for deposition. Our client responded to us that he emailed Mr. Zoo and that he would likely get back to us the next day because he's in Moldova and it was the middle of the night there. The next morning, before we heard back from Mr. Zoo, before our client heard back from Mr. Zoo, our client was detained and we haven't been able to have contact with him since. So we're not trying to willfully skirt the court's order, but we haven't been able to facilitate the deposition. Your Honor, if I may on that.
I mean, wasn't there something from the corporate counsel that said basically no?
Your Honor, what we received back from them was we will not assist. Now, that is what we heard back. Not we cannot. No, we will not assist in scheduling this deposition. And if their corporate representative had the email address to get in contact with Mr. Zoo, his counsel would have access to that email as well to be in contact with Mr. Zoo.
Again, they did not say we cannot, because our client was detained by ICE, we're unable to facilitate getting this forward. They said we will help facilitate this. So I'm not sure where that leaves us, other than that they were intentionally, willfully unwilling to abide by the court's order.
And that was part of the exhibit that we filed, Your Honor, was the exact response was, we will not be facilitating this deposition, which I responded using the language of the court of, you will not coordinate or effectuate the deposition of Mr. Zhu. The response from counsel was confirmed. And that was on December 3rd, 2025, Your Honor.
But again, in crafting a remedy, assuming I were to agree with you on that point, absent dismissing their claims, what's your remedy?
I don't believe there is a remedy other than dismissing their claims, Your Honor. At this point, we've not been able to conduct discovery. Discovery has been closed in this matter. There's been willful violations of this court's order to cooperate and effectuate the Tepe deposition of Mr. Zhu, and that the select corporate representative would be able to be deposed prior to the close of discovery. Those two things have not taken place. And quite honestly, according to what counsel has indicated here today, Your Honor, can't take place prior to the trial of this matter, which gets into a separate issue of, at trial, who is going to be here for Select Corporation?
That was my other question going to be, how do you prove any of the things in your complaint if your guy's in the custody of ICE?
It's another issue that I wanted to raise today. I wanted to preview that we intend to file a motion to continue the trial pending the outcome of Mr. Sayuddin's immigration proceedings.
Okay.
Your Honor, there are 4 witnesses that we are going to ask that the court strike. And that is the 4 witnesses that we've requested and sent subpoenas to or requests. So the driver,
Alexandra Lazar,
the corporate representative, Mr. Zhu, and then the 4th one was Mr. Sayuddin's wife. Okay, so we would ask that all 4 of those be stricken. In a motion in limine that I believe has been filed to not allow any of those 4 to testify as a remedy for this. So even if the court does not strike the complaint, does not strike the answer to the counterclaim, to at least, because we could not perform the discovery that we needed, strike them from potential witnesses. What that would do, that would in fact, it would preclude plaintiff from submitting anything, because those are the only witnesses they could possibly have for the trial. So it would in effect dismiss their complaint as well as dismiss their response to the counterclaim. So we would ask that all of those be stricken, if nothing else.
If I deny your motion to continue the trial, are we going to be followed up by a 41A? Is that a consideration in this, or?
I think with the pending counterclaims, Your Honor, that would not be permissible under the rule.
Yeah, I guess you're right. Okay. Well, that issue's not before me today. I got to figure out what I'm going to do with these witnesses and the discovery dispute. Anything else on that issue?
No, you're on.
Just that I think the striking of those witnesses would be a drastic remedy for veteran here, where our client went, or the corporate representative, particularly with respect to the corporate representative who went to attend the deposition and was arrested and precluded from giving testimony at the deposition. So I think it's a more sensible approach, taking into account the due process rights of all the parties, would be to allow the trial to be continued if necessary, and certainly we don't dispute that they have the chance to depose a corporate representative prior to the trial.
Essentially what you're saying is continue the trial indefinitely though, right? Because who knows what's going to happen with the ICE proceedings.
We'll try to get more concrete information about the status of Mr. Sayuddin's immigration proceedings and submit that with our motion.
Yeah, I mean, I think what you're going to find, counsel, is that's not possible. Nobody knows what's going on in those proceedings. and it's impossible to get information even when we have pending criminal cases in those. All right, well,
Just the last thing, Your Honor, if I may. Obviously, it's not before the court today, but he's indicated a motion to continue. We obviously would object. This was the third time that this matter has been set for trial in February based on prior continuance, and then the continuance based on the court's schedule for the criminal trial that was set this month when it was initially scheduled. And as the court just indicated, we still don't have any indication of the ability to depose the dispatcher, who was the only first-party witness on behalf of Select Corporation that was involved, as well as the driver, who has willfully failed to attend the subpoena deposition that we issued in this matter. And we have no idea when we may or may not be able to ever speak to Dimitri Sayudin as the corporate representative of Select again.
okay, court will take it under advisement. I'll give you a written decision.
Thank you, Your Honor.
We'll see you in a couple of weeks.
Thank you.
Thank you, Your Honor. I have had the opportunity to discuss the case and discovery and everything with Mr. Brandt. We are asking to set up for final settlement conference.
Final settlement.
Yes, Your Honor.
Jury final settlement conference will be set February 6, 2026 at 9 a.m. Jury selection will be set February 9th, 2026 at 8:30. Both of those proceedings are in person. Bond will continue. Okay.
Thank you, Your Honor.
Let's call the case of the people versus Jocelyn Karuna.
People. Good morning, this is Simone Carter here on behalf of Ms. Karuna. Ms. Karuna, state your name for the record, please.
Sorry. Good morning. My name is Jocelyn Caruana.
All right. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
The plea form indicates that the defendant would be pleading guilty to an added count 2 of operating while visibly impaired, the 93-day offense. Upon our successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of it. Is that correct?
That's correct. That is correct.
Ma'am, could you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right. State your name again for the record, please.
My name is Jocelyn Caruana.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could also order community service and any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order your vehicle forfeited, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. Do you understand that, ma'am?
I understand, Your Honor.
And understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
All right. And to that charge, how do you plead?
I plead guilty, Your Honor.
All right. Thank you. Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
All right. You had or caused to have signed an advice of rights form. Is that correct?
Correct.
Do you have any questions regarding any of those rights?
I do not, Your Honor.
You understand that you're waiving or giving up those rights that are contained on that form, particularly the rights in paragraph 5, which are your trial rights.
I do, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened or coerced you in any way?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will
Yes, Your Honor.
because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
April 5th, 2025, at the location of South State Street near East Michigan Avenue in Pittsfield Township, Washington County, State of Michigan. Were you operating a motor vehicle?
Correct, yes.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor.
What did you have and how much?
So I drank a shot of tequila and a shot of aloe. Shot was what it was called. I'm not really sure what it is.
Okay, were you stopped by the police or was there an accident?
It was an accident.
What happened?
So on April 5th at approximately 12:30, I was leaving Lucas substation. I had consumed the 2 shots that we discussed, and I failed to stop at a red light at the street of State Street and East Michigan Avenue and hit another vehicle.
Okay, did the police arrive?
Yes, Your Honor.
All right, were you ultimately arrested?
Yes, Your Honor.
And were you ultimately taken to the hospital for a blood draw?
Yes, I was taken to the station first and then taken to the hospital.
For a blood draw, correct?
Correct.
And were the results of that blood draw 0.117?
Yes, Your Honor, correct.
Okay, do you have any reason to dispute those blood test results?
No, Your Honor. I believe last trial the pre-trial, we discussed the difference between the BAC on a ticket versus the blood draw.
Okay, but you don't have a reason to dispute those blood test results of a 0.117, do you?
No, I do not.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
All right. Ma'am, I do have to advise you that if I accept your plea and you commit misconduct between the time that I accept your plea and the time of sentencing, that first of all, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which led to this plea?
None from the people.
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to probation or to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
At 9 a.m.
February 11, 2026, 9 a.m. Bond with its conditions will continue. Do I have probation intake? I do. All right. And ma'am, I'll ask you to wait on the line. We're going to put you into a breakout room with my probation department so we can begin the sentencing process. Okay?
Thank you. Thank you, Your Honor. Happy New Year.
Thank you. And to you. Court does call the cases of the people versus Devontae Connor Belcher.
When Your Honor, Raymond Cook for the people.
5 cases.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Connor Belcher for one of those cases.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Connor Belcher in the other 4 cases.
Sir, can you please state your name?
Devontae Connor Belcher.
Thank you, sir. All right, what are we doing?
Your Honor, we're here for a series of cases, and we're going to be working to get Mr. Connor Belcher into like a recovery court or a drug court program.
All right.
And so we're hoping for an adjournment for a couple of weeks to get that process started.
Okay, do you think you can is he held on anything else other than these? Or?
There's a PCC tomorrow for retail fraud in the first degree before, Your Honor.
Okay, so he's held, okay. So how much time are you going to need on?
2 weeks to get started. February 4th day is fine as well, Your Honor.
That is all correct, Your Honor. Yes.
All right. I'll adjourn all of these matters into February 4th, 2026, 9 a.m. Bond will continue. Thank you.
Thank you.
Thank you. Court calls the cases of the people versus Christopher Dale Chambers.
Morning, Your Honor, Raymond Cook for the people.
Two cases. They're arraignments without. Dale Chambers. Christopher Dale Chambers. No response. I'll issue orders to show cause on both of these matters for the defendant's failure to appear. Court does call the case people versus Brandon Davis.
Morning, Your Honor, Raymond Cook for the people.
This is Public Defender Natalie on behalf of the.
You have it. Brandon Davis. Might be Motorola. Brandon Davis.
Yes, I'm here.
All right, what's your name?
Brandon Hezekiah Davis.
Thank you.
Thank you, Your Honor. I'm requesting an adjournment. Mr. Davis' license is still suspended, so I'm asking for some more time for him to work on that.
How close is he to?
I don't think it was overly close. I don't have his drive record. But I think he's paying off some stuff at the time. It's working, as I understand the reflection.
Yeah.
So any date after the 4th.
February.
During the matter, you're gonna have to figure out what you're gonna do on this, because he's got to show some significant progress. I'll adjourn it to February 18th, 2026, 9 a.m. On continue. Court calls the cases of the people versus Matthew Wallace.
Conrad Solar on behalf of Crystal Township.
Good morning. Assistant Public Defender Lauren Perny on behalf of Mr. Wallace. Mr. Wallace, state your name for the record, please.
Matthew Wallace. Thank you, sir.
Your Honor, Mr. Wallace has a couple of cases in circuit court that we're kind of waiting to be resolved. His next court date there is not until February 4th. So I'm asking for an adjournment of these cases. Those are kind of driving the bus here.
They're okay.
I have no objection to a date before then to see if something moves. But he's not. His next pretrial is not until February.
The pre-trials on February 4th aren't until the afternoon.
Right.
Right. So he'd be, if I set it for the 4th,
he'd be here.
Called before.
Yeah.
Okay. And those cases are holding him, really.
Yes.
Yeah.
Yeah.
And there's another felony up for probable conference next week.
That is
new
true.
felony.
It
Yes.
was a new case, older date of offense, but
A new case that's coming before me for PCC.
Correct.
yeah, I think it's
Next week.
scheduled, not this Thursday, but
The 15th, the 15th.
15.
January
Yeah.
15th, yeah.
and I think that's obviously gonna probably follow the,
Follow with the, okay.
Yeah.
All right. So let's do this. I'll adjourn it to then February 18th, which will be my next date after the 4th, 2026 at 9. I'll adjourn both of these to that date. If something, because I think I have bonds on these cases just so that he's getting credit. But if something occurs, let us know. If he's going to be released on everything except these cases, let us know so that we can.
I do think he has released this, I failed to mention this, he has released the treatments on those other cases. And
on
the everything else, there's one coming to Your Honor today for these cases as well. Mr. Cook and I discussed it prior to the hearing. I think these may be the last ones that needed one. So he may be released treatment before then as well. I forgot about that piece.
Got it. Okay. Okay. I'll sign those orders. They're coming on these two.
Right.
Got it. Okay. That makes sense.
Thank you.
Thank you.
Yeah, so these are the last.
Court does call the case of the people versus Comaria Davis.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Davis.
She's there, yeah.
Where is she? Oh, yeah. Ms. Davis?
Yes, my name is Kamaria Davis.
All right, I'll need a camera on you, please. She just muted, and I need your camera turned on, ma'am.
Ms. Davis, there should be a little camera with a line through it. You gotta click that.
People don't know how to work Zoom. We're gonna stop letting them appear that way.
Ms. Davis, is there a problem?
You're muted, Miss Davis. Miss Davis, unmute. She is now gone. I will call her up at the end if she's not here. Unless she'll bench warrant, hold it to the end of the day. She'll need to present herself in person to the court. Court does call the case of People versus Michelle Campbell.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Campbell. Ms. Campbell, state your name for the record, please.
Michelle Campbell.
I have before me a plea form that indicates that the defendant would be pleading to the charge in case ending in 1259, where we pleading no contest to the charge of retail fraud second, a 1-year offense. Upon her successful plea to that charge, the other case, which is up for today, the case ending in 0533 would be dismissed. That's the court's understanding of the.
Yes.
That is accurate, Your Honor. I believe there was some indication that restitution be reserved for dismissed counts.
Okay, so what should have been put on here is she's going to pay restitution on all counts. Is there an agreement to that?
There is, Your Honor.
Yeah, have her sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give the whole truth and nothing but the truth so help you God?
Yes.
State your name, please.
Michelle Campbell.
All right, Ms. Campbell, it's this court's understanding that you are going to be pleading no contest to the charge of retail fraud in the second degree. Is that
Yes.
correct? That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. Do you understand that?
Yes.
And that the fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine.
Yes.
You understand all that? Do you understand what a no contest plea is?
Not really, Your Honor.
Okay.
This is my first time.
No, it's okay. But you don't understand what a no contest plea is?
Not really.
Okay.
I would like to understand.
Have you talked to your attorney about
A
that?
little bit.
Pardon?
A little bit yesterday.
A little bit yesterday, but you still need more time to.
I would like to.
Okay, let's listen. If I pass this case and the attorney can get back and talk to you, you think you'll be able to have a conversation to see if you understand what you're doing?
Yes.
Okay, so what I'm gonna do is I'll hold the files, we'll pass it. And when you get a break, go back and talk to her about what she's actually doing.
Sounds
Okay?
good. Thank you, Your Honor.
Thank you. Court calls the case, People versus, is it Oka's Michael Russell?
Morning, Your Honor. Yes, Your Honor.
Hold on a second. Why? All right, everybody thinks I'm mispronouncing names. That the way this reads is he has the longest first name known to mankind. And then I'm looking at the screen and it's just Mike. Do you see it?
No, yes, Your Honor, I do see it, and it looks like
That is all wrong.
they corrected it, but didn't give you a new sticker. But I got you. I got you.
See, and everybody was gonna blame me. I want it clear on the record, this is not my fault. And Mr. Elkins, I apologize for them doing this to you and me.
That's no problem, Your Honor. I got two middle names, so it's been an interesting time with that.
Okay. Court does call the case. Other people versus Michael Elkins.
This is Public Defender Natalie Tate on behalf of Mr. Elkins. Please state your name for the court.
Michael Elkins.
See, told you. All right, what are we doing?
We're actually going to be requesting well, frankly, lengthiest adjournment the court would allow. We also have some issues that he's trying to about Indiana DMV. A lot of it has to do with some payments he needs to be making down there. That being said,
Indiana.
yeah. Great place.
Is it?
I don't know.
They got a good football team. That's all I know about now. They got a good football team, but that's like a blind squirrel finding a nut. It just happened. So how much time?
As long as the court would give us, to be honest with you. We're going to try to see if we can make progress within the amount of time you would give us for an adjournment. And if not, I would then be talking to Mr. Cook about a potential.
About something. Okay. Why don't I adjourn this out to February 18th, 2026, 9 a.m. And bond will continue. Okay, Mr. Elkins?
Thank you, Your Honor.
All right, thank you.
Thank you.
And I apologize to all my good friends in Indiana. Alan made me say that. I believe in the hooch. Court calls the case, People versus April Fleming.
Good morning, Assistant Public Defender Lauren Penny on behalf of Ms. Fleming. Ms. Fleming, state your name for the record, please.
April Fleming.
Thank you.
You know, this is an adjourned date for the bond violation. We did file a release of treatment order that the court signed. The jail has that. We're just waiting for Ms. Fleming to be assessed, which hasn't taken place yet, but we're hoping now that everyone's back from holidays, we'll be done soon.
Oh, okay. All right. So you want me to put it out till the 4th and see?
Yeah, I think
see where we are.
We'll probably have some movement.
Okay.
Before then.
Before then. All right. During the matter, February 4th, 2026, 9 a.m. Bond continued. Thank you, ma'am.
Thank you.
Court calls the case, the People versus Sincere Godwin.
Good morning. Lauren Perry on behalf of Mr. Godwin. State your name for the record, Sincere.
Sincere Godwin.
Your Honor, we are asking for, I hope will be our last adjournment. Mr. Godwin and I spoke. He just wants to watch the media. There is a ton of media on this case. That's why we're asking for an adjournment.
A video?
Video, yeah.
There's a ton. I don't know how much that is of video.
It's a lot.
Okay.
A ton is.
So if I go to the 18th, you guys think you can get that done? Can you watch all that ton of video by that time?
I think, yes, I'm sure.
All right. Sir, I'm going to adjourn your case to February 18th, 2026, 9 a.m. All right, sir?
Okay. Thank you, Your Honor.
All right. Thank you.
Sure.
Court does call the cases of the People versus John Hart.
Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Hart. State your name for the record.
John Joseph Hart.
Your Honor, we are requesting an adjournment of the trials. Mr. Hart will be seeing Your Honor tomorrow for PCCs. I think he has 3 cases scheduled for tomorrow.
3?
Yes. So we're kind of waiting to see what happens on those.
Got it.
And Mr. Hart would like me to provide the court with an update. He's been very busy while in custody preparing to eventually be released. He is completing the Beyond Barriers class. He is doing Dawn Farm in the jail. He has been in touch with Dawn Farm about transitional housing when he's released from jail. Okay. He's also obtained a job for when he is released. And he's doing AA every day in the jail as well. So he wanted the court to know all the good things that he's doing. He's really taking, using this time well, and I'm going to get all this information to the people too. So when negotiations occur, that can be used, but he wanted the court to know all of that as well.
Okay, and on the housing issue, I don't know if he had a voucher or not, or is going to need the Rising Hope program. I think I've mentioned it to council, and just I don't know their entire procedure, but if he needs to get on a list or can get on a list or something like that, then that may help with the housing aspect.
If I may, sir, I appreciate your input. The transitional housing at Dawn Farms, I signed up for that already.
Okay.
I did transitional before years ago. I think Mr. Allen was around when I did it. Officer Allen, yeah, he
hold on a
knows.
second. How long ago was that?
I have.
How long ago was that with Allen?
Yeah, he's been around.
He's been around?
Believe me.
That's what I've always said about him. I said Allen's been around.
Oh yeah.
Yeah.
Believe me.
Okay,
He
go
knows,
ahead.
he knows what he knows. Okay.
Well, I know, right?
Yes, sir. Yes, sir. But I do have the Alcoholics Anonymous. I have the Dawn Farm intake, the group guidelines and expectations. And I have a letter for you, but I do appreciate your input, and I want to do this right this time.
Okay.
When I did it back in the day, it wasn't his fault. It was, if it was his fault, it wasn't of his own. It was mine. But I know what to do now.
You know what to do now?
I want to get rid of these. I want to get beyond the barriers.
Got it.
That's what I'm trying to do, sir. And I appreciate your input and your understanding.
Okay, very good, sir. Around back in the day. I know, right? Thank you, Bond.
I appreciate you.
Thank you.
What's the date for?
Did I give a date?
You did not.
I did not?
No.
I was so fascinated by Alan. I wrote it February 4th. Alan, back in the day. Wow.
Been around the block.
I know, he's been around. That's what he said. We'll talk about that. All right, no, I'm with you. Courthouse Gate, people versus Wilmer Hudson.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Hudson. State your name for the record, please, sir.
Wilmer Hudson.
Thank you, sir.
Your name request.
You know Alan?
Yeah.
Okay. All right.
I do.
I'm just gonna find out. I'm gonna find out everybody that knows Alan.
And we play basketball a lot.
Oh, is that right? Was that back in the day?
Back in the day.
Okay. Yeah. Wow. All right.
I'm telling the truth.
No, I know you are. We're just, the three of us are just finding this all out.
Yeah, he's always been quiet. He's been a quiet guy.
No, really not.
Yes.
No.
He has.
Then you got the wrong Alan.
He's been quiet. I'm for real.
No,
always quiet.
No.
Never gave him problems.
No, you need to see that man back there in chambers. All right, go ahead.
Your Honor, Mr. Hudson and I are still in communication about what he wants to do, so I'm just asking for a brief adjournment. I think the 4th will be okay if that's okay.
Okay. I'll adjourn the matter of February 4th, 2026, 9 a.m. Bond will continue.
Thank you.
Thank you.
I didn't know that.
Well, they say hi to each other. Reminiscing. Quietly saying hi. Courthouse case people versus Trevor Howard. That's what's called karma.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Howard. Mr. Howard, state your name for the record, please.
I'm not gonna ask. Go ahead.
Your Honor, we're requesting an adjournment of this pretrial for plea negotiations.
Okay.
I will. Mr. Howard wants me to address bond. The news I have for you is that I did speak with Mr. Cook. There's new cases that are going to be arraigned. So I think what would be best, Mr. Howard, if I may, is we keep that bond motion until we know what's happening with those new cases. Just to get the lay of.
And that would be correct, because I wouldn't change anything knowing that there's new cases until I can see what all of that is. So.
Yeah, I don't know if they're scheduled for arraignment, but I will get in touch with the magistrate and see if we can get that done ASAP.
Do you have any news on the other?
So new charges were authorized yesterday, so I don't believe they've been set for arraignment yet. The charges that were authorized are for fleeing and eluding in the third degree, 2 counts of that. The felonies, we called a couple of misdemeanors.
Okay, so let's do this and see if we can get it all in and sort of wrapped. I'll adjourn this to February 4th, 2026, 9 a.m. Okay.
Thank you.
All right, thank you. Court calls the case of People versus Francis Judge.
And this is Public Defender Natalie Pate with on behalf of Mr. Judge, who stands to my right. Please state your name for the record, sir.
Francis Judge. Thank you, sir. All right, what are we doing?
Thank you, Your Honor. Ultimately, I'm requesting an adjournment. Mr. Judge and I were just able to connect today this morning, and he now has my contact information. He will be going to be making an appointment with the Secretary of State to see exactly what he needs to do to get his license valid. He believes that there was some sort of judgment that he paid up, and he just needs to confirm some things, and I need to also look at his driving record. So I'd be asking for an adjournment sometime into February.
Oh, you think it might be suspended because of the civil judgment?
That financial obligation.
Yes.
They got it. I appreciate you postponed 3 times for me, but I wasn't able to pay it. I finally was able.
You finally did get that out. Okay, and so now you got to figure that out. Okay. So what I will do. So let me, just so that we're clear, the financial responsibility, you say you paid that?
It's paid, and
okay.
The Secretary of State's got the paperwork. They sent it to them.
Okay, because if the Secretary of State has it somehow or another, if that's the only thing,
then I'd be able to go get mine.
Then yeah, my record's still, my record's still showing. Okay.
I have right here.
Okay, but I'm just gonna say my record indicates it's still suspended, which would usually change if it's where he's got to get a new license, because, okay, I could see this. So at some point, the license that he had will have expired in 2023.
Yes.
So even if he's clear, even if my record still indicates suspended, it probably isn't suspended. He probably needs to go back and he needs to get his license reissued.
But this right here is a financial obligation, paperwork that you wanted me to.
I believe you. Who's here with you?
My mother.
Your mom? I believe your mom. I don't, you were iffy, but I believe her when she handed it to you. All right.
And yeah, if I may, Ryan, that does make sense, because I believe he states that he has his state ID, or he may.
Got it.
So yes, he would need to go to Secretary of State, his actual license.
So you can get that done by the 4th, or you want me to give you to the 18th of February?
I got to make an appointment with the Secretary of State. I'm sure I can get it done by then.
Well, let's do this. February 18th, 2026, 9 a.m. Give you some time, get the appointment, see what you got to do. If you got to take care of other things and do it. Okay.
Thank you, Your Honor.
Thank you, sir.
Thank you, Your Honor.
I'm an alum of IU.
Pardon?
I'm an alum of IU. Football team.
Yes.
First ever.
Well, it's a good team. I mean, a lot of people didn't believe it and you watch them and I will say they're for real. All right, take care. See, when he said he was an alumni, I was gonna go, hoo. But court calls the case. People versus Kawandaki Thomas.
Morning, Your Honor, Raymond Cook for the people.
I know what.
And Assistant Public Defender Natalie Pate with it on behalf of Ms. Thomas, who's saying to my right. Please state your name for the record, ma'am.
Kevon Quay, Cynthia Rose Thomas.
Thank you.
Thank you. Thank you, Your Honor. I'm asking to set this case for final settlement conference. I have had the opportunity to discuss it with my client.
Okay, was this the one you said we had other cases?
Yes, I think I counted
8. When are they up?
for sentencing next week.
Okay.
Yeah. I got it in line.
What? And you're aware of that?
Oh, the sentencing's next week, Your Honor? Yes, Your Honor. And she does have a release to treatment that Your Honor signed on this case, as well as her felony cases.
Council approach.
Yes, Your Honor.
To the whole retail price.
Felonies.
Yeah. See when he's. Just thought I'd.
Well,
No, I don't need an answer. I know you were.
we were going down one route and now we're kind of going down a different route. So, your Cook and I will be in touch.
I don't know what that means, but will the fourth be enough time?
I think so. Yeah.
Well, if it's not gonna, tell me.
Well,
Talk to me, Verity.
I won't be here, Judge. So
I know you won't. That's why I'm wondering if it gets shifted to someone else. Is that gonna cause a problem?
Oh my God. I'm like, is Mr. Brown listening?
Brown listening? Is he here?
I don't know.
I don't feel, hold it. I don't feel confusion in the air, so probably not. What?
So not right now.
I meant that as a compliment.
Yeah. You can say something. You can say.
I can set it for the 4th or the 18th. No, you two go ahead.
Can I speak to you? Your Honor.
Can you? Go ahead. What do you want to tell me?
I'm waiting, I've been here. Things have been postponed, but in all this time, I've been doing AA every day, either in person or online. I'm also doing school. I'm taking a business management class.
Okay.
Staying with my mom. I have the tether, obviously. I've had that for 5 months. So I just had my 5 months sober. And I've not been happier in 3 years. I drank for 3 years. That wasn't a lifelong thing. I was in a really bad relationship and it was just drinking. And that's how I got into the DUIs. I'm the happiest now I've been in 3 years since I'm away from that. And he's in jail and I don't ever want to drink again. That's how I feel. So I just feel like I'm really improving my life. Really, all my kids are proud of me. I've got my family back. They all support me. Yeah, I just wanted to get that out there.
No, that's
Thank you.
Who's here with you?
My sister.
Your sister.
From Florida.
From Florida. So that's one of the ones that came back to you once you stopped drinking.
What's that?
That's one of the ones that came back to you once you start drinking, that you found part of your family.
Yes, and my children. We had Christmas and it was, oh my God. Yeah, my whole family back.
That's fantastic to hear.
Yeah.
Miss Kiesling always has a family member here with her. It's very
I do.
nice.
Yeah, no, I remember, but they're different each time.
The first time he thought my son was going to be coming up here. I'm like, no, it's me.
Okay, and so, well, that's, it's always great to hear. And probably I would imagine for the last 3 years, certainly. Christmas wasn't Christmas. And then you got that back too, and you had a good.
I did. Well, I got rid of a bad person in my life and got the good people back.
And sometimes when you're drinking, you can't tell the difference, right?
What's that?
Sometimes when you're drinking, you can't tell the difference.
Exactly.
Between who's really on your side and who's not.
No, yeah.
And you get in a situation where you're almost afraid to move. But then once you do, you see that there's a good life out there.
Yeah. And I'm free of that person. He's in jail, so I'm all good now.
That seemed to make you smile more than being.
Yeah.
I'm just saying. I'm just telling you what I observed.
I can do all the good things, you know.
All right. Okay. All right. So how much time would you like to? Because you got to try to.
I know. Let's go to the 4th. I think I'll have a conversation with Mr. Cook. We had a conversation this morning. I think we can make some progress here.
You think so?
Yeah.
What, Mr. Cook isn't letting you make progress?
Oh, no.
Is he standing in your way?
He's hitting the ground running, making progress all the time.
Okay. All right. What I will do is I'll adjourn it to February 4th, 2025. 9 a.m. Both of these matters.
So I'll give us
okay.
2026, if I didn't say that right, 9 a.m. The bond will continue, and I'm glad you took the opportunity to say something to us. It always makes us feel good to hear those kinds of things.
Thank you for listening.
You're welcome.
Have a good day.
And welcome from Florida.
Right? Why would you come here?
You got to be enjoying the weather here. Yeah. See, the fact that she's up here with her sister from Florida, that's love. All right. Okay.
Thank you.
You guys take care. Court recalls case, People versus Jamonte Love.
Morning again, Your Honor.
Good morning again, Your Honor. Shauna Bassi on behalf of Jamonte Love. Mr. Love, please state your name for the record.
Jamonte Love.
All right. I now have before me a plea form signed by the parties that indicate that he's going to be pleading to count 2, guilty to operating while visibly impaired. The 93-day misdemeanor. Upon his plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement. Is that correct?
That's correct, Your Honor.
Correct, Your Honor.
All right. So, Love, can you raise your right hand, please, sir? There you are. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. State your name again for the record, please, sir.
Jamonte Love.
All right. You can put your hand down. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor, punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could also order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order your vehicle forfeited, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, Your Honor.
All right. And understanding all of that, you still wish to plead guilty?
Yes.
All right. And sir, to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form or had caused an advice of rights form to be signed. Is that correct?
Yes, sir.
Do you have any questions regarding any of those rights?
No.
You understand that you're giving up the rights on that form, is particularly the rights contained under paragraph 5.
Yes.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here to get you to plead to this charge?
No.
Anybody threaten you or coerce you in any way?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty?
Yes.
June 1st, 2025, at the location of Munger Road in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, you consumed intoxicating liquor.
Yes.
What did you have and how much?
I had 2 beers and a Long Island.
Were you stopped by the police or was there an accident?
Stopped by the police.
Why'd they stop you?
My wife and I had a big disagreement, and I was pulling out the driveway to go to my parents' house just to diffuse the situation. And
so the police had been called for some other matter. You were leaving and they stopped.
Yeah.
Okay. You're not disputing the right of the police to stop you in this case, sir, are you?
No.
All right. Were you then ultimately arrested?
Yes.
Were you taken to the police station or into a hospital?
To the hospital
You were
first.
taken to the
and then-
hospital for a blood draw, is that correct?
Yeah. Yeah.
Okay. And was the result of that blood draw for alcohol a 0.129?
Yes.
All right. And it also showed that contained in your system was THC or its derivatives. Is that correct?
Yes.
Are you disputing the blood test results, sir?
No.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to the consumption of alcohol?
Yes.
Sir, I have to advise you that if I accept your plea, between the time of my accepting your plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
Okay. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
No, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be February 11th, 2026, 9 a.m. Bond will continue. Sir, I'll need you to wait on the line. I'm going to put you into a breakout room with probation intake or my probation department so we can start the sentencing process, okay?
Your Honor.
Yes, ma'am.
Thank you. Mr. Love is asking the court if they would be agreeable to allow him to travel out of state for his son's track meet to Louisville, Kentucky from January 7th to the 19th.
Hold on.
That's February.
Son's track meet.
I'm sorry, February.
That's February.
Son's track meet in February what?
17th to the 19th.
17.
Through the 19th.
Correct.
Yes, sir.
It's his son? What's he run?
My son and daughter. My son is 12. He runs the 200, the 400, and 60-meter hurdles. He's a national champion, so we're trying to qualify for the Adidas Nationals in March.
Sounds like he's good.
He's really good.
He's really good?
Yes, sir.
Did he get that from you?
Yes, my family. And he's also
he goes, I can't run, but my family
no,
can
I
run.
can run.
I know.
He won
Any
Junior
objection?
Olympics last year.
Pardon?
He won the Junior Olympics last year for the 100-meter hurdles.
Did he?
Yes,
really?
Sir.
And he's from Michigan?
Yes, sir.
See, good things always come from Michigan. So he's gonna go down to Louisville and show them, huh?
We're gonna do our best to, yes.
I'm more confident than his daddy. I think he's gonna run the table. That's all right. Here's what I'll do. Defendant may travel, of course, to, and you said to Kentucky, correct?
Correct.
And that was 17th through the 19th. That includes your travel time, sir?
Yes, we will leave Saturday afternoon after his solo concert and band, and then we come back Monday morning.
And he plays band too?
Yes, sir.
You know, I hear about kids like this, and I probably should have done something in high school. But anyway, all right. 17th, all right. So it all indicate February 17th through the February 19th, 2026. All right. I will permit that travel. All right.
Your Honor,
Yes,
one
ma'am.
other thing. One other thing, Mr. Love is requesting of the court that he be removed from the sober link as this was an isolated incident and it is a financial burden on his family.
I understand that. I'm not going to remove it and certainly wouldn't remove it until I see an evaluation, in which time he'll shortly be set for sentencing afterwards. So that request I'll deny
Thank you, Your Honor.
at this time. All right. Thank you. And sir, I don't know your son, but just tell him on behalf of a proud Michigander and this judge, I wish him the best of luck and that I have faith that it's all going to be great. He's going to bring home gold. All right.
I appreciate that, but I also I messed up on the dates. My dates was January 17th, not February.
That's what your counsel said first, and then you corrected
Yeah.
it.
I was looking at my calendar. I'm looking at in front of me. I was looking at the wrong dates, but I'm sorry about that.
See, he would have missed the track meet. He would have been down there in Kentucky just wandering around. Nobody, you know, and you need to get it together. Okay, it's January 17th through the 19th. All right.
Thank you, Your Honor.
All right. Take care.
Have a good rest of your day. Thank you.
You do the same.
Thank you.
It's just both files.
Are they okay? Court recalls the cases of Michelle Campbell.
Morning again, Your Honor. We would go to the people.
Good morning. Assistant Public Defender Lauren Perny on behalf of Ms. Campbell. State your name again for the record, please, ma'am.
Michelle Campbell.
All right. And Ms. Campbell, we were at the point we had sworn you in. I told you what it said on the form you're going to be pleading to and how you're going to be pleading, and that was a no contest plea.
Yes.
I got to the point of asking you, did you know what a no contest plea was? You remember all that?
Yes.
And thank you for letting me know that you weren't really sure of that.
Thank you.
Okay. Did you get an opportunity to speak with your attorney?
Yes, I did.
Okay. So I'll ask you again, do you understand what a no contest plea is?
Yes, I do.
All right. Two important things about a no contest plea I have to make sure that you understand. And that you understand that it, first of all, means that you're not desirous or wanting to contest this charge of the retail fraud second. You understand that?
Yes.
All right. The second thing you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Do you have any other questions regarding a no contest plea?
No, I don't.
All right. Basis for the no contest plea, Ms. Brennan.
Lack of recollection.
All right. Ma'am, to that charge of retail fraud second degree, how do you plead?
No contest.
All right. Now you understand that by pleading no contest, you will not have a trial of any kind.
Understand.
All right. Now you signed an advice of rights form or had your attorney sign an advice of rights form on your behalf. Is that correct?
Yes.
Do you have any questions regarding any of those rights?
No.
You understand that you'll be giving up those rights,
Yes.
particularly the rights in paragraph 5 that are on the podium. You see that?
Yes. Barely. I don't have my eyeglasses.
Okay, but you understand that you're giving up the rights that were on the form
Yes.
and that your attorney explained to you. You understand you're giving up your right to appeal of right.
Yes.
All right. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
All right. The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 21-14925. Any objection to the court having reviewed that report?
No, Your Honor.
On a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, if I accept your plea, if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this?
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Satisfied, Your Honor.
Court will accept the defendant's plea of no contest to the charge contained in the case ending in 1259. Yes, that's right. And case ending in 0533, that is dismissed pursuant to that plea agreement. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be January 28th, 2026, 12 noon. All right. Bond will continue. Thank you, ma'am.
Thank you.
Court recalls the case People versus Comary Davis.
People.
Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Davis. Ms. Davis, state your name for the record, please.
Maria Davis.
Yeah, we are requesting adjournment to review media. Mr. Cook and I had a discussion today about surveillance footage. I think that's either at our office or on our way.
During the matter to February 4th, 2026, 9 a.m. Bond continue.
This is 11. I just moved it up.
You just moved it up. Okay.
Yeah.
Let me take a brief break, let everybody get where they are. I'm done with the investigation.
Yes, sir.
All right, court's in recess.
All right.
Hello, this is the Kinyarwanda interpreter. Did you need a Kinyarwanda interpreter?
Malicious mischief. The agreement was, I believe, that it be taken under section 771.1. It was referred for a pre-sentence report. Have you had a chance to review the report with them? And are there any material additions, corrections, or deletions?
Your Honor, yes, I have just two additions to make. As far as Mr. Cunn's employment status, he is still working at Ford, earns the same amount. However, he's going to be laid off on starting January 19th. So there's going to be a total layoff of 12 weeks, but it's going to be off and on.
I need to ask, let me ask you a question. I'm sorry. I need to ask if Joseph Naday from Gorno Ford is here. Joseph Naday. Come on up here. I'm sorry. I should have asked before. My apologies. Your name right there, that's a microphone, believe it or not, and right to your left. Your name?
Joseph Leon Naday.
Okay. I'm going to let them finish and then I'm going to come to you, okay? Go ahead, Mr. Carmen.
So, Your Honor, given the 12-week in total layoff, which is going to be on and off over the next few months, Mr. Cunt is going to lose a fair bit of income due to that. I should add, for dependent children, he has a son. He's 19, but he still fully supports them. So, of course, that factors into his income as well. But otherwise, I've gone over the recommendations of probation. Would ask that the court adopt those, please.
Is there anything you would like to say?
No, it's not. No.
So I read the report, Mr. Naday, and I just want to make sure my understanding of everything is correct. The defendant came over to Gorno Ford, and ultimately, because he was unhappy, he slammed a door and the window broke, right?
No, Your Honor.
What happened?
So he did leave aggressively. He slammed the door, but the window did not break. He punctured the wall behind the door.
I'm sorry. Okay. I'm sorry. All right. I'm sorry. The door swung open with enough force to damage the exterior of the building. All right. Do you have a bill for that? Did you cover, was it covered by insurance? Did Gorno Ford have it repaired? Did you pay?
We repaired it in-house, sir.
So there's no restitution that you're asking for?
No, we're just asking that he doesn't return.
Is there anything that you would like to say, Mr. Kerman, in addition to what I just said?
Yeah, nothing further. I will note the no contact and no return to the business as part of the report.
What was the service that was performed?
Just a oil change. So the individual came in around 2 or 3 o'clock, met with a service advisor, dropped off his vehicle. We shuttled him home. The agreement was we were going to be done with the vehicle by 6. I believe we got done with it at 6:05. We went and picked him up also. And then that oil change was free for another issue that we had previously. So we gave him a free oil change. We shuttled him home back and forth. He came back upset that it wasn't done at 6 o'clock. And I came out of the office, apologized to him. He was fine when we talked. When he exited the building, it was pretty aggressive. I went out there in front of him and asked him why he slammed the door. It was later that we pulled the video that he kicked the door open. But I told him I was going to call the police. He came up pretty aggressive. I don't recall what was being said. We were both yelling at each other.
You and him?
Correct. I told him I was going to call the police. He did stay for about 5-10 minutes. Then he left. He did get there. Detective called me the following day. They reviewed the footage. And that's the last I've heard about the case.
Okay. Mr. Naday, tell me, what, so you were upset about 5 minutes?
That's a total lie. If it was a buildup, I shouldn't have kicked the door.
Okay, I get it. Hang on.
Okay, good.
I want to know why you were so upset that would cause you to fling the door open and cause.
Because that was the 3rd time.
Let me finish. I want to know why it was or what happened that made you so upset that you would fling the door over and cause about $500 worth of damage to the exterior of the building. Now you can tell me everything.
That was the 3rd incident that I had coming up there. So
on this day?
No, 3rd time in a row that I came up there. It was you know about Maul because a manager had got fired for the first week. So
say that again.
I said he knows about the incidents, about 2 or 3 of them, because the manager got fired from the first. That's why he's the manager now, because the first one got fired because the incident with me.
Is that true?
No, sir, that's my recollection. I've been there 15 years and we didn't fire an employee due to a customer interaction.
It wasn't the interaction, it was the service that he did.
Don't talk to him, talk to me.
Oh, it was the service. It wasn't the service. It was when I went up there, the guy broke the nuts on my car live. The guy who did the front wheel alignment, he know the whole story. That's why they gave me was giving me a free oil change because of what they did to me, how long. So, but this last time I went up there, I dropped my car off at 10:30 in the morning. 10:30 in the morning, I dropped my car off. This is probably on the paperwork. Around 3 o'clock, 3:30, I start. They said it was gonna be 3-4 hours. About 3-4 o'clock, I called, and I had other appointments, so called about 3 or 4 o'clock. Basically, every hour I called, they told me we're on our way in an hour. So from 3, they closed at 6. So at 3 o'clock, 3:30, they told me somebody's on their way. I called back at 4
to pick you up.
Excuse me?
Somebody's on their way to pick you up.
Yes.
Okay.
So at 3:30, I called them, nobody came. 4:30, I called them, nobody came. I know they closed at 5:30, I called them. Again, like, what's going on? So they came and got me about 5:45, and me and him talked about that and everything. And yeah, on the way out, I missed a couple points. I was like, yeah, I kicked the door. I did.
Okay, I mean, sometimes people get busy. I'm not condoning.
I understand that. That was, I don't condone it. I don't agree with it. That was the third incident. And I was, fed up, and I had a lot going on in my life, and I was triggered. So, yeah, they didn't get the car at 3:00. They got the car at 10:30 in the morning.
Okay, but still, I mean, sometimes that happens.
I was wrong. You're right. A lot of things happen. You're right. I understand.
See, I just, I'm not trying to. We all lose our cool a little bit. This just seems a little bit over the top, don't you think? I mean, you're kind of justifying your conduct
I
here.
didn't justify it at all. I said I was wrong 2 times. I didn't justify it. I don't justify it at all. It was stupid and impulsive. I didn't justify it 1 time.
You make more than 910 per week, right?
No, I don't.
How much you make per hour?
$40.
40 times 40 is 1,600. How do you come out to 910? Net.
Taxes.
Well, we all pay taxes. This is the United States.
I could show you a check right now.
No.
$835.
Well, but they're taking out what? Child support or something?
No, I don't pay child support.
Are they taking out?
I found a single zero.
Hang on. Are they taking out some car payment, or are wages being garnished? There's no way they're taking out. There's no way they're taking out $700.
Single zero in a loan from myself.
All right.
That they're taking out, for hardship loan that they're taking back from my pay. Yeah.
Okay. Anything else, anybody?
Your Honor, I'd like to speak.
Sure.
Courtroom's been around for a long time. We're all very family oriented. I don't want to see any harm come to this gentleman. We're very second chance. We just wish that he doesn't return. That's all I like to say.
Well, I'm not sending him to jail.
And I don't have a problem. I've been going on for how many years? Yeah, I've been going.
All right, talk to me now.
I've been going there for years. I had no problem spending my money there. Years.
All right, but well, I'm just going to tell you one thing, and then I'm going to sentence you. And this is not going to be overly oppressive, but you have to understand something. You're telling me that you were wrong, but then you're justifying your conduct. So I don't know which it is, but I'm going to let it go. 12 months probation. I'll take it under section 771.1. That was the agreement. You cannot leave the state without the consent of the court. You cannot violate a law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. You're to attend the anger management weekend program. You're not to enter 21111 Allen Road in Woodhaven. You're not to have any contact with Joseph Naday. No contact with him. You cannot write, phone, see, text, email him, communicate with him, have anybody else do any of those things for you or on your behalf. 1 day court work program. There's a $35 charge for that, and 1 day of community service. You're going to do 1 day court work. It'll be a Saturday or Wednesday. There's a $35 charge. You're going to do 8 hours of community service. I want that done by February the 15th. And you're going to pay fines of $100, costs $100, $75 victim charge fee, $50 justice assessment, 3 1/4 probation fees are $240 for $565. Attorney fees, I'll only charge $40, that's $605. And your court work program fees is $640, that's $35 plus the screening fee, $700. Restitution, if any, to be handled through civil litigation. So no contact, don't go back there. 8 hours community service by February 15th. We'll schedule you a day on the court work program. And that, sir, is pretty much it, except I just need to check out something. You do need to go over, I'm going to order you to go over to Woodhaven to get fingerprinted and photographed, okay? So you have to go over there today. You have to go over to the Woodhaven Police Department to get fingerprinted and photographed. by 2 PM today, okay? By two,
So, like, you go to Woodhaven Police, that's the one on, West Road?
correct. Weston Hall Road. I'm gonna give you a review hearing date. You go down the hall, you'll get your review hearing date in paper form, and then you'll go over to probation and you'll be instructed, and then you'll go over to Woodhaven. I filled out an order for you to go over there and get printed and photographed. All right, Heather, what do you have for me in 12 months?
That'll be January 6th of 27.
Review hearing date will be January 6th of 27 at 8:30 in the morning. And do you have, how much of this $700 does he have?
I don't have anything right now. I don't have any money right now. I'm going through some things right now. I have a good job.
Okay, slow down. It's fine. Tell me when you think you can pay this.
I'll say.
Hang on, slow down. I'll set you up on a payment plan. Tell me when you can start and how much you can pay.
You can start me up for Fridays. I'm gonna be on it for a year. You can put it $50 a week. Well, I'm sure I'll pay it way beforehand, but I don't want to over.
You pay $75 a week, and I'll start this beginning on February the 27th. And if you don't have the money, no problem. You come and talk to me or Zoom in. You call the court and ask for an extension. I'll be more than reasonable. You okay? So if you don't have the money, again, you just don't worry about it, but you got to call and Zoom in, or you got to come and talk to me, and I'll be happy to give you an extension. Just don't.
Just one more thing, my client is asking for permission to leave the state January 19th. He's planning on visiting his brother in New Jersey. His brother is ill.
Okay, give me the file back, Gene, or wherever it went. I need it back. How long are you going to be gone?
Just the weekend.
All right, I'll just say can leave state between January 19th and January 26th. I'll just say, I know you only said you're only going to be gone a couple days, but just in case, you can leave state between January 19th of 26 and January the 20th. I'll make it January 27th of 26 to go to New Jersey. Okay. Anything else?
No, sir. Thank you very much.
Thank you very much. Good luck. Thank you, gentlemen. Have a good day. Labadie. Reed Dean Labadie Jr., 25W18.
Morning, Your Honor. Jim Gamber, on behalf of Mr. Labadie, he's also present, go ahead and speak your name. Very Labadie, gentlemen.
So
He can solve this judge.
he keeps. What's this under Hyder or what?
Yes, sir.
Okay, let me just check something here. All right, your name?
I'll get you in.
All right, Mr. Gamber, I'm sorry, your appearance again?
Yes, Judge, Tim Gamber, P78192, on behalf of Mr. Labadie.
All right, so he's charged with window peeping at a resident's address.
196 High Clark Court.
All right, and he's going to plead guilty to that, and that's going to be under the Home Youthful Trainee Act?
That's correct, Judge.
Is that what you want to do?
Yeah.
So if you plead guilty to this, I'm going to place you on probation. I'm going to refer you for a pre-sentence report. You're going to come back. I'm going to place you on probation. The possible penalties here are up to 500 fines, 93 days jail, costs of all those. I'll defer the proceedings, set terms and conditions, and if you're compliant, the case will be dismissed. Do you understand? I can't hear a word you just said.
Yeah.
Did you sign the advice of rights? You didn't sign it. I gotta have you guys are killing me. It's just. I'm gonna take a 5-minute recess, everybody. Stay seated, please. Why you guys, Laney. Charles Laney.
Are you calling us, Judge?
Yeah, Charles Lester Laney, 25W839-812, 25W839-811A.
Morning, Judge McNally.
Hang on one second. I gotta find all the cases here. B and C. Name? I'm not excited about this at all, Mr. Gaith. I'm gonna adjourn it to February 4th. There will be no more adjournments. February 4th, give me a trial date. That's gonna be a bench trial, Heather. And I will be happy to do that. I took the waiver of the jury trial already, right?
Yeah.
February 4th.
Do you want to do that at 11 o'clock, Judge?
That's perfect. February
Okay.
4th at 11. Do not ask me for another adjournment, though, okay? That's it. February 4th at 11. You can go down the hall, sir, and you will get your new notice. Anything else?
Nothing.
Thanks a lot. Yeah, good day. People against, I'm going to take a recess. Stay seated, everybody.
What's up?
Who had you call my husband?
Who had you call your clerk?
Say
What's your name?
Come on up here, Mr. Blisman. Thomas Robert Blisman, 25-706-462. Sometimes I get busy. That's my apology to you, sir. Your name?
Thomas Blisman.
You're here for a review hearing. You've done everything. Defendant not required to serve jail term right now anyway, you know, as long as you keep being compliant, okay?
Yes.
Not required to serve jail. Heather, we don't need no further review hearings necessary, okay? So you don't have to appear for these every 4 months, since you're doing really well. Okay?
Okay, thank you.
Sorry to keep you here so long. I really, I don't know what to say. Thank you.
Hey,
You're
Judge,
doing great, Tom. Keep it going.
for Miss Harvey, her husband did call in and approve us to apply the bond for her.
Perfect. And now that file, I'm going to take Mr. Gambers first with Mr. Labadie. Dean Labadie Jr., 25-28-2910. All right. Sorry, guys. Your appearance again, sir?
I'm sorry, Ryan. Tim Gambra, 78.
That's all right.
To you on behalf of Mr. Labadie, who's also present.
Your name, sir?
Reed Labadie, Jr.
All right. So we have the
Advice.
advice of rights signed.
Yes, Your Honor, may I approach?
Yeah, you can hand it right to my recorder there. And I'm going to ask, let's start over now, sir. So you understand, I'll take this under that section. I'll take your plea. I'll refer you for a pre-sentence report. I'll set terms and conditions. And if you're compliant at the end of the specified period that I set, the case will be dismissed. The prosecutor here says 12 to 18 months. Do you understand that?
He had said 12, Judge. I know that I think he crossed part that said 18 out.
Okay, well, I may still go 18. I may still go 12. I don't know, but I'm
Fair play.
okay. But do you understand that, sir?
Yeah.
All right. And you understand if you plead guilty, the possible penalties are up to 500 fines, 90 days jail, costs of all those. Do you understand that?
Yes.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes.
All right. Okay. Any questions so far?
No.
To the charge of window peeping, how do you plead?
Nothing.
On November 13 of 25 at 4:37 in the morning, were you at or near 19116 Hyde Park Court in Woodhaven?
Yes.
And you lived in New Boston, right?
Yeah.
And you were looking inside somebody's windows
Yes.
at 4:30 in the morning?
Yes.
For what purpose? Just be honest with me. Was he intoxicated? Yes?
Yes.
Well, I can't take his plea if he can't make out a factual
Well,
basis.
I think he has sufficient recollection to be able to handle this. I just think that some of the finer details might be.
Well,
He recalls looking in the window.
Why were you looking in the windows?
I used to live there.
You were looking in the window. You used to live there with who?
My dad,
Who's your dad?
Reed Labadie.
Same name?
Yeah.
May I, Your Honor?
Yeah.
So they had previously, that was an address that they had previously lived at. So they had subsequently moved, but he found himself back at that address.
What were you doing, looking in what window?
I'm not sure.
You just looked in the window at 4:30 in the morning?
Yes.
Did you know the people that were living there at the time?
No, I thought I lived there. So,
You thought you still lived there?
Yeah.
What did you consume that day? How much alcohol or drugs or both?
I just saw
How many? What kind?
Nick also.
How many? 20?
Too
I can't hear you.
many.
Are you on probation or parole right now? Anybody force you to plead guilty? I'm gonna accept your plea. I find it to be an accurate plea made voluntarily and understandingly. Please accept it. Does he have a drug or alcohol problem or?
He does. It was.
Well, I know, but if he's drinking this much where he doesn't remember and thinks that he was living there at the time, I mean, that's kind of scary. It's not to say that.
I think, Your Honor, that I understand your concern on that. I think from my perspective too, though, it's, I think it's better, or at least there's a more reasonable explanation than just walking to a random house. He had previous.
I'm just saying, all I'm trying to say nicely here is if he thinks he lives at how long since you'd lived there?
Like 2 years.
He's going back to a house he hadn't lived at in 2 years. I mean, he must have been seriously under the influence. That's all. Here's what I'm doing. I'll accept the plea. I'll take it under 769. I'm not sorry, 7694A. I'll take it under the HIDA statute 762.11, refer you for a screening and assessment. You're going to be screened and assessed today and sentenced at a later time. I want you not to go back to 191. These are conditions of your bond. Do you understand that? I'll give you $1,000 personal bond, but you are not to go back to 19116 Hyde Court in Woodhaven, not to be within 2 miles of there. You're not to have any contact with the victim at all. You cannot write, phone, see, text, email, or communicate with anybody there. No alcohol, no marijuana, no illegal drugs. I do want him going to NA at least 2 times per week in person. And I also want him going over to get fingerprinted and photographed today by 2 p.m. at the Woodhaven Police Department. Do you understand that, sir? So you're going to get a review here. You're going to get a sentence date. Then you're going to go down the hall and pick up the sentence date on the notice. Then you're going over to probation. We're going to notify the victim. Probation will you'll fill out a questionnaire to them and be interviewed, and then you'll come back for sentence. So why don't you give me another date, Lisa?
Your Honor, if I may, will the screening done by probation, will that not indicate then that they make a recommendation as to whether or not he has any kind of drug or alcohol problem? Because I think that if we look at it just this one incident, that yes, that there are some concerning aspects of it, but I really honestly do not believe that he has an alcohol problem.
He drank so much, he thought, I'm going to assume that he's been truthful and thought he was going back to his house. That's a blackout to a blackout to a blackout. I mean, if you go back to a place you haven't lived in 2 years and you start peeping through the windows and now you're in here telling the judge that you thought you lived there. I mean, if that isn't indicative of an alcohol problem, I don't know what is. I mean, I'll make a determination after I read the report, but he's going to go to AA. If anything, I think I'm at least a couple times a week too light. Mr. Crawford, you see the AA verification there. So we're going to hand that to you. You're going to give it to your client. He's going to go in person.
Judge, is there any way you could delay this now? He's having second thoughts about this.
No. Are you kidding me? What do you mean he's having second thoughts? Because I ordered him to go to AA? Are you kidding? There's only one of two things that happen here, son. You either were drunk out of your gourd Or you were going over to the window, peep somebody, or both.
Yeah.
Hang on. Listen, I don't appreciate people arguing with me. You can disagree with me. It's okay. Nobody's ever heard me say I'm always right. But in this instance, if I don't order what I just ordered, I'm a bum. If what you told me is true. You thought you lived there. You hadn't lived there in 2 years. Did I misunderstand something? Did I misunderstand something? Then you are kidding yourself. You are kidding yourself. And it's okay, I guess. I'm not going to having second thoughts because he doesn't like the judge order him to go to AA twice a week or abstain from alcohol. Which is it?
Well, I think it's more so about his condition at the time as far as the knowledge of what he was actually in fact doing. And that was my concern. I'm not trying to throw a wrench in the machinery at all, Judge. You've been very reasonable this morning from my perspective.
Well, I'm not understanding though. He's looking through the windows. He's at 4:30 in the morning, which causes me to say a lot of things to myself. I mean, I wouldn't go to my house sober even and look through the windows at 4:30 in the morning. I'm going to walk in the door. He didn't even try to walk in the door. I don't know what to say to you. You act like I'm sending you to jail for 90 days. This is strange. I'll do the screening. We'll see what happens. I'm going to keep an open mind, but he's going AA. I mean, I just cannot imagine a scenario under which I wouldn't order it then. Give me a sentence date, Heather.
That'll be February 4th at 9:00.
Is that good with you?
That's good with me, right? Will he be on, so the AA class will be done in the interim until the sentencing date?
Correct.
Fair enough.
He's going to go down the hall. He's going to get his notice. He's going to get an order for prints, and he's going to get his bond sheet. My court officer is going to hand him an AA verification. He has to go in person. Every time he has to have the form signed, and then he'll come back for sentencing, and I'll revisit it. But I don't know what else to say. I'm surprised that he thinks it's unreasonable. And, you know, it's okay. You're entitled to your opinion. It's all right. I don't expect everybody to agree with me. That's not going to happen. Good luck. We'll see you back here. Thank you very much. And you have to go over to Woodhaven to get printed and photographed. Okay. So now, who did you say again, Heather? Shaquila
Harvey, yeah.
Shanta Harvey. I'm sorry. 25W838-266B. I'll note for the record that 266A, count one, 266A, no insurance was dismissed, and the driving on a suspended was dismissed, and I accept your plea to allow an unlicensed driver to drive your name, ma'am. You called your husband, he's going to allow you to apply the bond, right?
Judge,
yeah.
Just to let you know, on that no insurance, if I'm looking correctly, there is a suspension on that.
You're going to have to pay that to get the suspension lifted from your... I mean, frankly, I'm surprised he's dismissing it, but I'm not going to quarrel about it. But you're going to have to pay the clearance fee on that, okay? It's $45. Anything, you still wish to waive your right to a lawyer?
Yes.
Anything you'd like to say before I sentence you?
No.
100 fines, 200 costs, 75 victims' rights, $50 justice assessment, 4 1/4 or 60 days. And then you're going to apply that. You're going to apply the 45 for the clearance fee, so that's 480. I'm sorry, 470. And then the other money is going to be sent. We have to send it to your husband, okay? And we'll go from there. They'll explain everything to you down there. I sincerely wish you well. Good luck. Paul Edward Fortuna.
Yes.
Mr. If you're ready with something, tell me which ones. I'll call them. Come on up here, Mr. Fortuna. 25W840-237. Which cases do you have today?
Molinari.
What else? What else?
Fritz.
Molinari and Prince. All right, it'll be next. Sir, your name?
Paul Portuno?
You're charged with drunk driving, OWI. You have the right to a lawyer. Would you like a lawyer?
Yes, please.
We'll give you a lawyer. You go out in the hallway. And he's going to set you up. My court officer is with an attorney, okay? Janaya, Amani, Ariane, G. Neely, 25W839-8298 and B and C. Come on up here, ma'am. So the other files were taken down. Your brother didn't show up. You're charged with driving on a suspended, operating while intoxicated and open intox. Your name? You have the right to a lawyer. Do you want one? You should get one on a drunk driving.
Yes.
Okay, John, set her up with a lawyer. Molinari, Madison Gabriel, Alvin Molinari, 24W8355562. Your name?
Madison Molinari.
Okay, so you went through probation. You're all set. Your name?
Madison Molinari.
Raise your right hand. You solemnly swear affirm on the penalties of perjury, the testimony you've given these proceedings to be the whole true self you got.
I do.
Technically, his, what do I say? His representation ceased at the time of the sentencing. Since you were in court on January 22nd, have you been arrested?
No.
Any new charges?
No.
Any contact with the police? No. Defendant compliant, case dismissed. Congratulations to you on motion to prosecute. This was technically your representation ceased at the time of the sentence.
Sure.
I'm going to go ahead and dismiss the case. We're all set. You're all set. Good luck.
Thank you.
Prince, Kevin, Jaron, Darrell Prince, 258-726-159. Mr. Prince, come on up here.
Vice Law representative, Mr. Prince. This, please make correct.
Did he sign an advice of rights?
Today.
Is it
For sentencing and,
This is for a sentencing?
yeah, sentencing, there's a bond violation, allegations of a bond violation also, but this is.
I didn't even see this file. My apologies. I thought it was just a probation violation.
No, it's bond, alleged bond violation.
So I ordered him to test that day. Okay. Who's his probation officer, Ms. Tessino?
Yes, John.
My mistake. I saw the,
Hello?
I need John Kevin Prince in here, okay?
Okay, I'll be in a second.
Thank you.
Yep.
So, hang on. Mr. Tessino swore to bond violation I wrote on December 22nd. Defendant did not appear for testing as ordered on December 16th. On December 16th, I found him guilty of violating the bond and ordered him to test that day. Mr. Prince didn't think he had to test apparently. That's what I'm reading out of it. So we got a big problem, massive, huge. I don't know what he's thinking. So I'll listen to whatever you have to say. I'm going to sentence him on the bond violation. I'll determine how I'm going to proceed, and we will go from there.
Wait for Mr.
I don't need to wait. I see what happened now. He violated my order.
Well, you're, it's.
What happened? Did he get run over by a truck? Did he have a heart attack? Why didn't he go test on December 16th?
He would have came tireless, however, he held up very close here by the train. It's not an excuse, it's just what happened. He doesn't, he's just, he now knows he needs to come a little early. I told him we have a interesting train schedule around here, but he needs to not cut it so close.
Do I look stupid?
No, you're right.
I must. I often question how stupid I must look. Your name? I want to make sure I understand this. There has to be, I must be misunderstanding. You swore out a bond violation. He came in front of me. I found him guilty of violating the bond condition. I ordered him to test on December 16th and he didn't test. Is that true or false?
That is true, but he does have an explanation.
What's the explanation? Well, forgot about, he told me, his lawyer just told me he got stuck by a train.
That is the explanation he provided me as well. He emailed me. It was a train, but I also, sounds like there was some confusion with the testing times in the evening.
How?
That he thought they were later than they were, and they're just from 5 to 7.
And I believe he's released some pictures to show that he was at least physically in that area trying to get here.
Yeah, and he did email me. I didn't print the email. I should have printed it. He did email me, but and I explained to him that nonetheless, he missed the test, and then his next test wasn't until December
22nd.
18th.
That's why I would submit that if he would have tested right now, he would test negative.
Yeah, I know, but that doesn't tell me anything.
Understand. It's a snapshot of where he's at.
Go get the email.
Okay.
What train? I can't hear you.
The one on Van Horn?
Van Horn?
Yes.
One right out here.
Yes.
You live in Flat Rock.
Yes.
Why'd you have to come from the north?
We came from Van Horn coming east. So
Van Horn coming east.
stuck after I-75.
Slow down. Where were you coming from? Flat Rock?
Yes.
All right. The train is north of Van Horn.
Yes.
Why would you have needed to drive north of Van Horn instead of turning right on eastbound Allen and turning into the courthouse?
I got to come on the other side.
I can't hear you.
I come from the other side of the Telegraph, so I take Van Horn from Telegraph. I'm all the way here. So the direction from Van Horn.
I thought you said you just got stopped here on Van Horn.
Van Horn on the other side of Allen Road, coming from I-75, coming towards this courtroom.
I never dealt with this case at all. You know that? I never had any of this case before me, ever, except on the bond violation. What time did you leave?
I left here.
No, not here. What time did you leave to go test the DNA?
6:30 p.m.
What time's DNA open?
6:30 a.m. to 9 a.m. and then again 5 to 7 p.m. So he emailed me on the 16th at 7:32 p.m. and said, been here for 15 minutes. And he did provide 2 pictures of the train, but DNA was already closed. And then I emailed him telling him I was confused. And he said, sorry, I meant to send an explanation with the pictures. Yesterday after court, I went straight to go drop like the judge asked, but DNA was closed around noon, which would be true. They're open 6:30 to 9 a.m. And he said then I had to be to work around 1:30 p.m. I planned to go after work that day, but I had got stuck by the train again. And by the time I was able to get around to DNA, it was closed again. And he put in parentheses, I thought it was open till 9 p.m. So I had planned on going this morning, and when I called the DNA number, no colors were called, which was accurate. DNA wasn't open that day.
Where's the picture? Can you tell where the picture is taken on what track?
It's black and white, and even I don't know if he has the picture, it looks,
Let me see.
it's hard to see, and it's dark, so that doesn't really help.
Well,
He lives on West Huron River Drive, right?
That's where I say this.
I can't tell, make heads or tails out of this.
Your, my client and I both understand frustration with what seems like.
He had a 4.61.
My client understands he's got a drinking problem.
Does he live in Flat Rock?
Yes.
Did anybody talk to him about sobriety court?
They have. I'm just looking forward, if we would get to the sentencing, to joining sobriety court. It's been approved. He's ready to
He's a
go.
candidate.
He's a,
He was scheduled for sentencing today. He was the email, the vote email, he was on there, and for whatever reason, everyone responded to both, and you only responded.
well, because this was not put down as my case.
So
I don't know what happened. This is what I'm talking. There's just too many mistakes.
well,
This was listed as Judge Hessen's case. This is not Judge Hessen's case. She took the plea in my absence. I've never seen Mr. Prince, except for the bond violation hearing. I've never talked to Mr. Prince. Have you been at any of the status reviews that I've had?
yeah, he missed this morning. I was thinking about it.
Well, when was he at a status review? The plea was taken on November.
There wasn't, he would have been, I believe, one, but he didn't have one in December because of the holiday, so he would have been probably at one before the holiday.
Were you at a status review with me?
No.
It's never even been at a status review. I didn't know who he was, and they said it was Judge Hessen's case. I had no reason to quarrel with.
Explain that? So he was on probation with Judge Hessen for a separate OWI. It was in warrant status, if I remember correctly, she revoked the probation. You were off that day. That's why she arraigned him and referred him to you. This case.
No, I know, this was my case.
Yeah.
She took it in my absence. I don't know where I was on that day, but she took it in my absence. I get it. I'm not quarreling with that. But I was I'm not voting on who's going to be accepted into Judge Hessen's sobriety court or not. And I was told this was her case. I don't remember this. I mean, if it was that good at remembering every face that came in front of me on every case that I ever handled, I have no business being here. I should have been present. Give me a break. Here's what I'm doing. What's that?
He was referred for your sobriety court on the new case.
I know that.
Okay,
But I've never talked to the man. I didn't take his plea. I never saw him at a status review. The email sent out said that it was Judge Hessen's, and I wasn't going to vote on it since it was Judge Hessen's case. Here's what I'm doing. I need to back up on this. I'm not doing anything right now. I'm going to adjourn the sentencing for a couple of weeks. And I'm going to take a look at everything. I didn't even read anything on this because I did not believe it to be my case. So I will adjourn this 2 weeks. I'll adjourn the sentencing. Are you here on the 21st? Well, I'm not here. Heather, I need you to give me another date, please, for a sentencing.
That'll be February 4th at 9 o'clock.
Sorry, I got to go all the way to February 4th at 9 a.m. But I just do. I didn't even read the report. I don't even remember seeing this blue back in my file today. Maybe.
That I will say because of bond violation, I brought it down to say this morning. So
Yes.
I will say.
So
But
I didn't see the report.
I understand the confusion of the email.
I'm putting this back. That's what I'm doing. He's to remain, and then I'll decide when I talk to the other people in you or whoever else. I'll decide what I'm going to do on this, but I can't. You're going to have to go down the hall and get another date, sir. I'm sorry.
Fair enough.
You understand? All right. Thank you.
Thank you.
Johnny Thornsberry. Where's Johnny Lee Thornsberry? These guys want me all to come out and give them. Is that what I have to do?
No, Your Honor, I tell them every time, have season.
I believe you. And this isn't signed either, but that's okay.
Well, there's not really, there's a prosecution working on it.
He sent it in. He sent it in saying he'd give him 7411.
Sure, he told him to come to court.
Yeah, I haven't presented it to my clients. So.
All right, good enough. Why don't you take the file? And you can go to
Mr. Compton.
Where's Jonathan Compton? Is he ready?
Send follow.
There's another one in here, attempt to retail fraud. You want to talk to Mr. Compton too?
No, we're ready.
People against Jonathan Glenn Compton, 25W839357.
Good morning, Your Honor. Michael Crawford representing Mr. Compton.
Compton, your name?
Jonathan Compton.
For purposes of arraignment, does he stand mute and waive formal reading?
Yes.
Your Honor.
All right, so now I'm entering a not guilty plea, and now he's going to plead to the added count of attempt retail fraud with a retail fraud to be dismissed. True?
True, Your
Does
Honor.
he have any priors?
Nothing aware of, Your Honor.
Have you been in trouble before? I'm going to find out.
I got
Fraud, Your Honor.
Talk to me, Mr. Compton, yes or no?
as for only I know is I got a case in Oregon, Ohio.
I
but
can't hear you.
I'm sorry. Can you hear me now?
Yeah, come on, tell me, what have you been
sorry.
involved in?
Traffic. I have like a speeding ticket.
Speeding ticket. I'm talking about a criminal offense.
I have a case in Oregon, Ohio, but it's pending. It's not.
For what?
They saying that I stole something that I didn't steal.
Okay. Any other convictions? Do you have any convictions so far?
No, I have
besides
no.
this one?
I have no convictions of.
So he's
criminal
just going to
stuff,
plead
no.
to attempt to retail fraud. Where's Signet, Ohio at?
I live in Port Clinton, Ohio. It's a little bit east of Cedar Point.
Okay, so you're what, an hour and 20 minutes, hour and a half from here? Is that about right?
Yeah.
Do you still live in Signet, or is that just an old address?
That's my old address. That's
What's
what
your
I
new
live in.
address?
335.5 Superior Court, Port Clinton, Ohio.
Hang on, Superior Court?
Yeah.
And that's in Clinton, Ohio?
No, Port Clinton, Ohio.
Fort Clinton, Ohio. What's the zip there?
43452.
All right, so he's going to plead to attempt to retail fraud. I'm going to take that plea, and then he's going to, the retail fraud will be dismissed. This isn't to be taken under any statute or anything. That appears to have one prior property crime. So that's what he's doing. If you plead guilty here to attempt retail fraud, the possible penalties are up to $250 fines, 45 days jail. Costs are all those. Do you understand that?
Yeah.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to a trial by court or jury, right to question their witnesses, right to bring in your own, right to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and we will not have a trial. Do you understand that?
Yes.
To the charge attempt to retail fraud, how do you plead?
Guilty.
Were you on November 29 at 25 in the city of Woodhaven, County of Wayne at Walmart, 23800 Allen Road?
Yes.
What did you do?
I thought the camera scanned and it didn't, and I just walked out. That was my fault.
Hold on. Did you take property intentionally that was offered for sale and walk past the cash register without paying for it? Yes or no?
Yes.
Well, then what are you talking about? You thought you scanned it and you didn't. Did you steal this property intentionally, or did you mistakenly take the property past the cash register?
I took it past the cash register.
You intended to steal the property. Is that true or false?
True.
Then what were you going on and on about some camera that you didn't, the camera didn't scan it? What are you talking about?
That's what, I mean, that's just something I was talking to. I'm sorry. It's my bad.
Are you on probation or parole?
No.
Anybody force you to plead guilty?
No.
What's a tacticam? I've never heard of that. What is a tacticam? Do you know?
I think it's somebody using the course of hunting for deer and set it up area if I see this motion.
All right. Anybody force you to plead guilty?
No.
And that the property was recovered, right?
Yes, right.
Yes.
Plea is accepted to attempt retail fraud. The retail fraud's dismissed. How far is Fort Clinton? You're about am I right? About an hour and 20 to an hour and a half?
Yeah, something about that. Yeah.
Where does he work?
He's not working right now, Your Honor. He's in a major car accident. He's not able to work right now. But he is prepared to submit some type of payment arrangement to take care of whatever fines and costs for his.
Anything you'd like to say, sir?
No.
100 fines, 180 costs, 75 victims' rights, $50 justice assessment, 405 or 45 days. How much can you pay today? Anything?
Your Honor, my client couldn't pay anything today. We need to submit if you can pay $100 every 2 weeks starting January 16th.
I'll do that. $100 bi-weekly beginning January 16th. Listen carefully. If you don't have the money, no problem. Call the court. We'll go on Zoom. I'll be glad to give you an extension. Don't ignore me, okay?
Okay.
Thank you. Good luck. Thanks a lot.
Thank you.
have that other one to take care of, right? Okay, thank you. All right, counsel, are you ready on one?
Yes, sir.
Do we have that file? Did you make it up? Okay. Roberts, Jeremy Christian Roberts. Jeremy Christian Antonio Robertson, 25W8370064. Your appearance?
Good morning, Your Honor. Peter Bernardo, P78413, LNAC, representing Mr. Roberts.
Your name?
Something here, Roberts.
So he stole something, he's gonna plead him to disorderly.
Disorderly.
And there's $1,146 that he stole?
Yeah, Your Honor, if I could explain that.
Yeah, I can't wait to hear. It should be a felony.
Your Honor, Mr. Robertson is a barber, and one of his clients, who he had only cut his hair one time, asked him for help to go to Lowe's to basically bring some building materials from Lowe's to a building site because he knew he had a pickup truck. So he agreed to help his friend out, went into the store with him. They collected whatever materials they were. His client, everything that was on both his cart and his client's cart was scanned through, but unbeknownst to Mr. Robertson, the card was declined. And since it was a self-checkout and the person wasn't actually watching what was going on, this client gave him the nod that everything was okay, and then he went out and loaded his stuff.
So he didn't intend to participate in it.
Correct. And then
then the prosecutor needs to revisit this. He shouldn't be convicted of spitting on the sidewalk. I don't care what it is, if he didn't participate intentionally in a retail fraud or a larceny, and that's what it sounds like. So you better go talk to the prosecutor again. If we have to, we'll set it for trial or another pretrial, but I can't take a plea even to disorder if he's saying he didn't do anything wrong.
He again,
that's fine.
The video and the photographs show.
Well, then the criminal justice system is terrible if we're having him plead guilty to something and he didn't do anything wrong intentionally. He still has to intend to steal, right?
Can I ask if we can set this for another pretrial?
Yeah, I'll do that.
And that'll give me a chance to actually, because he had the video on a disc, but I had to look over the shoulder of the detective to watch it. I didn't actually get time to watch it.
You don't have to explain to me. I'll adjourn this for another pretrial. Wait a minute. How many times are we going to adjourn this?
There was a counsel issue last time, Your Honor, with Attorney Crawford.
But he didn't show up July 23. He didn't show up August the 6th. I'm setting it for either jury or bench and a final pretrial.
Final pretrial.
Heather, I think I can do this one on the 28th at 8:30, can I? That's what I'm going to do. October the 28th at 8:30. Are you here that day?
Yes.
Okay, that's what I'll do. Is that all right, Heather, or somebody going to get mad?
No, we could probably get that done at 8:30.
Just make sure everybody's here at 8:30 that day. If it doesn't resolve, I'm setting it for trial.
I understand, but again, we're going to come back on 120.
Correct.
January 28th. Okay.
You can talk to him further, but I can't take a plea if he's saying he was duped into stealing something.
Well, since I actually after I met with the prosecutor and I talked to my client, and actually we have now a name of the individual.
Good. Maybe you can turn it over to the police sooner rather than later.
I've got more wiggle room now with the prosecutor than I did before.
Okay, good enough. We'll see you here then.
Right.
Good luck. Go down the hall and get your handwritten notice. Thank you.
Yeah, I'm waiting for trying to come up in.
Yeah. Yeah, I don't know when they're gonna log in, so. It'll probably be a little bit.
Strung out there.
They are, Judge. I'll bring him in.
Did Mr. King talk to a lawyer? Did you talk to a lawyer, Mr. King?
I talked to someone, sir. I talked to a lawyer, yes, sir.
Can you hear me? Yeah, he can hear you.
Oh, okay.
He's just waiting on your counsel to,
Johnny Luke Thornsberry, 25W839-358. Come on up here, Mr. Thornsberry.
Morning, Your Honor, my co-call person, Mr. Thornberry, he's approaching.
Your name, sir?
Johnny L. Thornberry.
This is possession of cocaine, right?
Correct, Your Honor.
He stands mute, waives formal reading.
Correct, Your Honor.
Does he have any prior drug offenses?
No.
This says that he's going to plead guilty.
The 7411, yes, Your Honor.
Yet another one right after this in Lincoln Park, it looks like.
Yes.
If you plead guilty here to possession of cocaine, I'll take this under 7411. Possible penalties they're charging under local ordinances up to 500 fines, 90 days jail, costs of all those. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you will be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
Any questions? To the charge, possession of a controlled substance, specifically cocaine, how do you plead?
Sure.
On November 14 of 25, were you in the city of Woodhaven, County of Wayne?
Yes.
And were you specifically at West and Gudith at 1:43 in the morning in Woodhaven on that date? And were you in possession of cocaine?
Yes, sir.
Was it in a vehicle, on your person? What?
A vehicle.
And were you driving the vehicle?
Yes, sir.
Were you by yourself?
Yes, sir.
Where was the cocaine in the vehicle?
It was sitting under the armrest.
And you knew it was there?
Yes, sir.
It was your cocaine?
Yes, sir.
Are you on probation or parole?
No, sir.
Anybody force you to plead guilty?
No, sir.
Please accept it to that charge. I'll take it under 7411. I'm going to refer him for a screening and assessment. I'm going to give you a $2,000 personal bond. You cannot leave the state without the consent of the court. You cannot violate any law. You must appear in court as directed. Do you understand all of that?
Yes, sir.
Also, I want you to understand, you are going to go over to the Woodhaven Police Department by 2 p.m. today to get fingerprinted and photographed. That is a condition of your bond. You understand that?
Yes.
You're going to be screened and assessed today. You're going to fill out a questionnaire and be interviewed as soon as you leave the court. First, you'll go down and get your notice of your court date. Then you'll come back over to probation. You are going to undergo a screening and assessment. You're going to go to AANA at least 3 times a week. You are going to test weekly. So I just want you to be aware you're to test weekly, and they're going to set you up with testing. So you're going to be tested weekly. You're going to go over there. You are going to be tested weekly. They'll set you up. They'll give you a color every time you go. We will receive the results, and you're not to purchase, possess, or consume alcohol, marijuana, or illegal drugs. So weekly testing, no marijuana, no alcohol, no illegal drugs, in person, AA, screening and assessment, test weekly. I'm going to give you a sentence date, and that will be in this case on.
It'll be February 4th at 9:15.
Okay, February the 4th at 9:15. Okay.
Thank you, man.
Do you understand everything? You got to get off of this stuff.
I just got out of.
I don't want you to talk. Okay, good. Show them that. But I don't want you to talk about the case, but it scares me. 11 days later, you were getting picked up. Don't even mention it. Don't talk about it. Good luck. Daryl King Jr., 25G 306-414, 21T-636-962A and B. And can you get that last one done for me, Mr. Crawford?
Yes, so I can file.
Okay.
What? I don't know. I think that was the last.
Didn't you have another drunk driving or something?
Oh, that was, yeah.
Okay. Your appearance?
Daryl King Jr.
Your name, sir? Your
Daryl
name?
King Jr., sorry, sir.
Detective, your name?
Detective Corporal Sean Fine, Trent Police Department.
For purposes of arraignment, he has 21T-636-962A, B, and C. He doesn't show up in court. And he also has 25G306-414. Does he stand mute, wait formal reading?
Yes.
Well, he's another one that's going to end up with a bond. And then people will say, well, the judge locked somebody up on a suspend. What do they want us to do when the guys repeatedly don't show up? And then they tell us stories. I mean, he's missed multiple times on these cases. 1, 2, 3, 4, at least 3 or 4 times on these cases. So I hope you got some money with you, Mr. King. Hope you've enjoyed playing fugitive. Where does he work? How much does he make?
It's not working right now. He was picked up going to the job.
Picked up going to a job interview. Where was the job interview?
At Walmart in Dearborn off Southfield Road, sir.
Well, I don't know what to tell you. It's bad. I don't know what to tell you. Did Redford turn him over to you guys? I mean, Dearborn turn him over to you guys, Corporal?
Your Honor, I believe he was stopped in Riverview, and Riverview turned him over to us.
Why were you telling me you were going to Dearborn Walmart? You live in Redford, right?
Yes, but I stay on I stay in Riverview, Michigan, 19470, and that's where I was coming from. Riverview, Green Trees Apartments off 4th Street, sir.
I'm not sure I understand. How could you get okay. Anything else?
Judge, that's from his previous criminal history, apparently it's some kind of an assault from 2015. So he did a few months in Dickerson and then successfully completed probation. He hasn't had any serious criminal events since, other than just the traffic violation.
You don't show up. Judges can't give personal bonds. Pass it around when you're down there at Dickerson or wherever they take you, okay? 3,010% on 962 A, B, and C combined. 2,010% on 306-414. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. The earliest date I can give you, I'll give you tomorrow. I'll be more fair with you than you have been with us, okay? That'll be January 8th at 10 o'clock in the morning. You're all right with that, aren't you? Us being
Absolutely,
more fair
sir.
with you, us being more fair with you than you have been with us?
Yes,
You're
sir.
okay with that, right? I mean, you don't want me to treat you like you treated us, are you? Do you? Or else I'd set this for next July.
No,
Right?
sir. Thank you, sir. Yes, sir.
How old are you?
I just turned 36, sir, and just got married.
Quit acting like you're 14. Stop doing this. Have them fill
Yes,
out
sir.
a petition for court-appointed lawyer, detective. Thank you.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. Mr. Polk, do I have a case with Mr. Polk? He keeps popping his head in.
No, I just put him in a breakout room.
Does he have a case with me?
He does. I told him he had to file his appearance. He said he thought he filed it. It's with Wells.
What kind of case is that?
That one is operating with a high BAC, it looks like, Judge. I just finally threw him in there because I've had an attorney and a client in with York for quite a while, and Mr. Polk's been waiting, so I finally just threw him in there.
that the last case, the one with Mr. Polk? Do you know, Heather?
No, there's another one that's been in with Mr. Urick for a while for Sticatelli. And that's Attorney Puda in there with them.
What time? Yeah. What time were those cases scheduled, out of curiosity?
Wells was for 10:15 and 10:30 was Sticatelli. Well, I said they've been in there for quite a while, so finally I just threw Mr. Polk in there instead of waiting any longer.
All right, good enough. Thank you.
You're welcome.
Where did your kid live? That's some issue.